order. I believe it's December the 16th, 2015, approximately 6 p.m. And I think the first business is called to order.
James Grundy.
Here.
Rupert Friday.
Here.
Stephen D. Simone.
Here.
Thomas Callahan.
Present.
Dr. O'Neill.
Here.
Mr. Vice Chair, you have a quorum. You have 5 members present.
Wonderful. One thing I forgot at the last meeting, because I'm new at this, is we have two, because we're on camera, as you probably, or some of you know or don't know, but in any case, we have two cameras, one on us and one on that podium. So if you're going to speak, you speak from there, please. So last meeting, we have people talking from the back of the room and whatever, and that doesn't record the meeting correctly. And obviously it gets a little discombobulated, so we will get to the public later, but in any case, the 2 cameras, the 2 microphone locations, okay? So I guess the first thing on the agenda is the extension of time over Boston Neck Road.
Meeting schedule? The meeting schedule?
The meeting schedule, oh, that's right, yeah, forget it. Take it back. 2026 meeting schedule has to be approved. Anybody have any questions or comments? There are a couple of Wednesdays thrown in there. You guys saw that, right?
Yeah. I noticed that February 18th is Ash Wednesday and March 17th is St. Patrick's Day. I don't know if that matters to anybody.
Yeah.
If I could just say that this follows the typical routine schedule of the 3rd Tuesday of the month, barring the holidays, which necessitate the Wednesday meetings.
Okay. So we have those 2 Wednesday meetings, and nobody has any problems or objections? We need a motion on that?
Yes,
I know I'll be gone for the 16th of June, not that I'm asking you to change it around, just for the record, I'll be out of here on the 16th of June.
Okay.
I'll be traveling.
I move we adopt the 2026 meeting schedule as presented.
Second.
All those in favor?
Aye.
Aye. Okay, now finally we'll move on. Extension of time is the heading of the topic. Old Boston Neck Road, LLC, Santilli, Master Plan Approval, Plan NB, Lot 30A, 500 Old Boston Neck Road. I believe Mr. Doherty is here to present.
I was first. How did I get bumped from you?
Check out the agenda.
They updated that. Just you wait.
Do you want
I
to know what you have to
object.
say in advance? Hi, Patrick Doherty for OBNR LLC. I'm here requesting a 1-year extension pursuant to Rhode Island General Laws 4553-4. The project was denied but then approved by the State Housing Appeals Board on December 28th of 2023. And the town later appealed that action to the Superior Court. It was heard by Judge Landfair and decision rendered in May, I believe. But in going through, ordinarily vesting has been interpreted to comply or go from the date of the appeal as well, but in the Low and Moderate Income Housing Act, the vesting provision that's contained in there doesn't speak to appeals of any decisions. So out of an abundance of caution, I have come in before the date of the December 28th decision of the SHAB to seek a 1-year extension that's granted by right on request of the applicant. And I'm here to answer any questions you may have regarding that.
Start with you, James.
I mean, my question for the solicitor is exactly what was just said by the applicant. Does the date start at the award or does it start at the appeal? Because the town, to take an appeal, must have thought they had a reasonable possibility of overturning it, which would somewhat hinder the applicant from going forward.
I think in this instance, you could say he wants a belt and suspenders on so his pants won't fall down. But I think for precedent reasons, your question is appropriate, and it begins at the time, especially as we're winding down SHAB. There's still cases in the pipeline, because SHAB doesn't exist anymore. but there's still cases in the pipeline that are being dealt with in the Superior Court. So I think the period that he should be concerned about, and I would interpret the statute this way, is that is the date that Judge Lanfair made his decision. And from that date forward, the 1 year.
Has a preliminary application been filed for this?
Well, I can answer that. We submitted for preliminary plan back on June 19th, 2025. Was confirmed as received by the town by email on the 20th of June. There was incompleteness comments that were issued on July 9th of 2025, which was 20 days after submission. That was time that the administrative officer has a 25-day review period under the statute. But that didn't set the clock at 5 days. The statute also allows for a minimum of 10-day review period upon resubmission. So we went ahead and resubmitted on August 28th of 2025. That was confirmed and received by the town on the 28th of August as well, which would have put the 10-day completeness re-review deadline at September 7th of 2025, which was 10 days after the resubmission. There was correspondence from the town that didn't comply with the statute. It was sent out by email on the 16th of September. And the basis was that there was a traffic report that was referenced as not being included with the materials, but that's not, in my opinion, that wasn't a sufficient reason because the traffic report was submitted with the master plan submission. It was a pretty lengthy report on that. In addition, there was on the landscape plans, I guess the name of the project, even though it showed the plat and the lot number and it showed the subject property, it was the wrong name of the project. And also that there were no deeds submitted with the submission. But I would posit that those are not sufficient reasons under the law because obviously you don't know what your deed is going to convey until you've got some kind of specificity with regard to the units. So we have a 20-unit division, and the reason I applied the belt and suspenders here is I anticipate that there may be some form of litigation because I think, it's my opinion, that this preliminary plan has been granted by default under the statutory deadlines that are set forth in 4553-4, specifically subsection 2D, failure to act, which says that the failure of the local review board to act within the time prescribed period constitutes approval of the preliminary plan, and a certificate of the administrative officer as to the failure of the local review board to act within the required time, and the resulting approval shall be issued on request of the applicant. Further, if the public hearing is not convened or a decision is not rendered within the time allowed in subsections D2, 3A, IIIA, and D2, IIIC of this, which references the process that's supposed to take place and the time frame for the review board rendering its decision within 90 days from the date of the certification, that it shall be issued immediately. So the reason I'm here to do this is to protect my client because I believe that the town has granted it by default with regard to that, and we may or may not be in litigation regarding that issue, but I just want to make sure that I'm vested to give me the time to deal with what I need to deal with in the courts, if that need so arises. Full disclosure.
Anything else, James?
Trying to count some
Trying to
days.
count,
So
okay.
someone else.
Well, I can count the days. So from August 28th, it was September 7th, the 10-day resubmission. And the law is pretty clear that the certificates shall be issued within the 10-day period or not. And even so, again, with regard to this particular matter, I believe, and I think the court agreed on review, that the town didn't properly treat the application going forward at the master plan review. And that we had to force a hearing with the former administrative officer, Mr. DeLuca, because he was continuously issuing certificates of incompleteness, and they weren't for valid reasons. They were for the fact that we didn't have the final approvals from the state authorized certification of the wetlands, and those are not appropriate for a master plan approval, which is just a general conceptual overview. And while I do respect the body, I also respect the law, and I'm fully pursuing my client's rights in that regard.
Dr. O'Neill, may I respond?
Sure, please.
Thank you. Unfortunately, Mr. Doherty didn't give me the courtesy of letting me know any of this ahead of time. We could have had a conversation. I did not receive any response email from him positing that he was not in agreement with the incompleteness letter, which, by the way, I believe the law says not less than 10 days.
Mm-hmm.
Correct. And you, Mr. Doherty, did you say responded in 16 days the second time?
And so you responded on the 16th, which was 9
The
days.
7th to the 16th, was that 9 days?
That was 9 days after the deadline. The statute that gives the administrative officer no less than 10 days.
No less than 10 days.
Excuse me, no less than 10 days to respond and issue that certificate.
Mhm.
That not less than 10 days is the maximum. The 10 days is the maximum that you had on a resubmission.
Right, so the law says not less than 10 days. So I just want to be clear, and Mr. Doherty did not respond to me in any situation. I wish he had. We could have had a conversation and worked out the kinks ahead of time. But I just want to put that on the record so that you're hearing from staff as well.
Thank you.
My question is a little bit more aligned with, once a preliminary plan is submitted, in your view as the planner, does that stop the preliminary plan stage? And does the master plan become vested? Now we're working on the clock of the preliminary plan.
We're working on the clock, I believe we're working on the clock of the preliminary plan because the master plan, as the number of units was vested through, as you know, Mr. Grundy, through SHAB and through the land court.
So once a good faith effort is made to go forward, and I'm not going to get into the days right now, I think, my question is, are we actually beyond the master plan stage, and are we working through the preliminary plan stage, which doesn't actually have a fixed time to get to the end as long as all of the parties are moving forward? So if everything you did from the town standpoint was timely, are we actually in the midst of a preliminary application and there isn't a need for the extension?
Well, I can answer that in particular, because the law that I just read...
Wait.
Go ahead.
Oh, go ahead.
No,
I think the question was over here, yeah.
You're putting it to me.
Yes.
I believe you're right, Jim. I believe that it is, there are deadlines to respond, but there are not deadlines for the application if it's going back and forth and being worked on. There's no drop dead of 6 months, 9 months, until the application is worked out and that both parties are not sitting on it, but rather going forward in an aggressive manner as the statutory scheme implies. Then there is no drop dead date of dismissal.
So the question is, my question is kind of, do we even need, is this even a proper thing to do if we're at the next stage?
He's worried about litigation.
Let me explain why I'm here, because I'll cite the provision of the law exactly. The failure to act provision, which is contained in 45-53-4 2D, that provides that there's a step that needs to be taken by the applicant, and that is to request of the administrative officer to issue the preliminary plan approval. And that's contained, if you look at it, it says, if the failure of the local review board to act within the prescribed period constitutes approval of the preliminary plan, and a certificate of the administrative officer as to the failure of the local review board to act within the required time, and the resulting approval shall be issued on request of the applicant. That's why I'm here. I want to get my master plan approved or vested for an additional year, and then I'm going to request that the approval be issued pursuant to subsection 2D of the statute. I have not done that yet, so in my opinion, any approval, it says it constitutes an approval, but the statute also contemplates that there shall be a certificate issued by the administrative officer, and I think that certificate would be the operative document that would have the date. And I can state on the record right now that I'm not holding up the town, or we're not arguing that the time period for approval of a final submission is anywhere running at this point.
So I think I've complicated a very simple question into 3 sub-questions. So the first question would be, I have no issue making a motion regarding the vesting because it is by right by statute. I think based on the solicitor's comment, we would actually be making the 1-year extension based upon the May 2024 Judge Lanfair date. So it would be a year from May, but they could ask at any time. And then the issue regarding completeness, incompleteness, and dates.
Jim, let me know, you just said May 2024, did you mean 2024 or 2025?
We would, I believe Judge Lanfair, from what we were told, it was May 2024. We'd have to get the exact date for the motion. But they get 2 years on the initial. That would bring us to May of 2026, and we could add that additional year any time that they're asking. With reading the statute, there's nothing in here. They could ask for that the first day that they're in, if that's correct. Then the third issue is something that I think is going to have to be hashed out with legal parties to figure out whether or not this response was sufficient or deficient related to the dates. I think that that's a separate issue that
By legal parties, you mean our council?
I think our council and their council and staff would have to work that out, because it sounds like there's an interpretation of what it's got. I think it's going to come down to what documents are required at what level of application, and what was provided and what was not provided, and what constitutes enough of a deficiency to be non-responsive.
So unless I'm missing it, your wording, this proposal before us is why are we discussing the year extension if these other matters have to be worked out?
I think because the applicant is
because he's
asking
requesting
for it.
it.
He's requesting it and he's allowed to by right.
Yep.
I don't know that he needs it.
Okay, that's a good point. No other comment there, Steve?
Hey, so you're doing a great job, obviously, representing your client. I think we are getting out a little over our skis here. What we're here for is to give you or not give you an extension. Bob, is that extension by right to the applicant for 1 year?
Yes.
What are we doing? So it sounds to me like we give you the extension, and then you hash it out, council to council. Jill can get involved. She's very helpful. I'm sure you guys can come to terms that you all agree on. But for us, for tonight, we're here about a 1 year extension. You asked for it. It sounds like I have to grant it anyway, not that I wouldn't. So I'm done. I'm all set.
That's interesting. How about you fellas?
So Bob,
Yeah.
I'm taking Steve's point of view and then in considering Jim's. Is there a downside for us to grant this evening?
No.
From a legal point of view, there's no downside.
No, if we denied it, he'd go to court and the judge would order it,
Okay.
in my opinion.
All right. And the second thing is just that I've been thinking about this. Typically when a master plan gets approved, the decision is basically recorded on the land records. What is actually recorded on the land records right now?
Probably a master plan decision
Yeah.
to the administrative office and the signed, actually, I'm not sure. about
No,
that.
you've got a master plan denial.
Yeah,
if I'm not
denial, that's
mistaken.
true, yeah.
So what in fact is on the land records right now?
I'm not sure, I haven't looked at that, but I do have a Superior Court decision.
No, I
And I
understand.
have the State Housing Appeals Board decision granting it.
But there's nothing on the land records here evidencing that you've got master plan approval. At this moment?
I can't
at this moment
answer
in
that.
time.
Yeah, I'd have to look at the
Thank you.
title.
Thank you.
So what you're saying, Bob, is that we all have to say yes?
You could say that, yeah, yes.
Oh,
I would suggest that,
As I understand what
I
you're
know you
saying,
would suggest it, but
as I understand what you said,
yes.
we don't have to say yes, but if we don't say yes, we'll get subject to
It'll get
litigation.
appealed.
Right.
And I might add too, if you read Judge Lanfear's decision, he left the door open for the award of attorney's fees on application later on, depending upon the success and the merits of the application. And that's just out there as well under the Equal Access to Justice Act. I'm full
yeah, no,
disclosure.
I hear you, but you know, we've gone through this in the past, Patrick, and you know where I'm coming from, and you know, we voted 4-0 that this is the 10 pounds of potatoes in a 5-pound sack.
Mhm.
So it's hard for me to sit here a certain number of months later and support the project going forward, even despite the legal basis that we're talking about. So my own feeling, these folks will do what they're going to do with it, but I would just abstain from a vote if I can't vote negatively, because I feel negatively, not about the proposal, but about the volume of the proposal. So, in any case, that's my feeling on it. So we have to move on to vote. You're not going to comment, right? Okay.
So you need a motion, Doc?
Yeah.
So I'll move that we grant an extension for the master plan approval that was granted through the SHAD decision for 1 year.
I'll second that.
All those in favor?
I'd like to
Which one do you
discuss.
Well, I'm requesting a 1-year extension, but I could not find anything under the vesting provision in 4553.
1 year from what date though?
Well,
SHAB or the judge's decision?
I'd like to say the judge's decision, but I didn't see anything in the law that gives me that under the Low and Moderate Income Housing Act, so I think I'm going to have to be, at a minimum, I'm going to have to do the December 28th decision of 2023 from the State Housing Appeals Board, just simply because I couldn't find anything in the Low and Moderate Income Housing Act that invested beyond that on an appeal. And I, as a former, solicitor for cities and towns, ordinarily it would be from the running of the exhaustion of appeals, but I didn't see. I've seen it in planning and subdivision laws, but I haven't seen it in the Low and Moderate Income Housing Act. So I wish I could insert something in the law magically, but I didn't see it. So we'll certainly submit before that. So.
Okay. So the vote was on the floor here now. It was already proposed and seconded.
So, different date though, right?
It's
No, the
December,
SHAB.
what's the date, December?
December 28th of 2023.
So you would be looking for from
For
this
1 year.
1 year from that date?
Yes, and we would be given by right another year from that
Right.
date as well on that,
Okay.
by right, just by simply requesting it to
All right.
the board.
So that's what's on the floor. We vote the proposal on the secondary. Everybody voting?
Yes.
Yes. Yes. Yes.
Yes.
Yes. Abstain. For 4-1, whatever you want to say.
401.
Pardon?
401.
401. Is that the way it's written? Oh, okay.
Thank you.
Thank you, Patrick. Take care. Okay, moving right along. We move on to some site reviews.
Jack, you're not up.
I'm not up here?
Oh, I'm sorry.
Moving along to site reviews, we
Check
have
the agenda.
Healy, Plat A, Lot 2, 129 Boston Neck Road. And the summary of this application before us, the application is requesting relief of prior unpermitted construction of a 27 by 21 foot cabana and patio located in the southwestern rear corner of the lot referenced above. This project requires a variance and a special use permit from the Coastal Resources Overlay District Section 4.4. Property is also located in the Special Flood Hazard Area, Section 4.7. So, would you want to explain to us this? Everything here is interesting. But this one is very interesting. Fire away, big guy.
I only handle interesting cases. Jack McGreen for the applicant. Applicant's Joseph Healy. Property is located at 129 Boston Neck Road, which is a couple of houses down from the Dunes Club to the right. Located in an R80 zone, and it has a lot area of about 69,920 square feet. The applicant's builder reconstructed a storage unit on the site without pulling a building permit. No denial about that. My client was unaware for what that's worth, but he's on the hook for his actions of his contractor. That being said, the storage structure, oh, let me give you these pictures. I don't think we have these. These pictures are kind of before and after pictures. It's complete now, but it's a couple extra pictures. You'll see that there was an existing storage unit on the property. And storage structures, as you may or may not know, but it's cited in the staff report, FEMA VE zone is limited to 100 square feet, and the rebuilt storage structure on an existing pad is 420 square feet. Since the town doesn't have local building code of appeals authority, we'll be seeking relief from the state building code standing committee, and also we'll be seeking CRMC approval. But the matter before here tonight is before this board because it's in a coastal overlay district and it requires a special use permit. So we have to address the development standards as set forth in that section. There's 6 or 7 of them. And so I do have Molly to this from the pre-engineering here to just quickly run through those standards, and then obviously to answer any questions that you may have. I'll also address the special use permit criteria, which in my opinion, many of them are in violation of the state 45-2412, because as you may or may not be aware, the statute was amended a couple of years ago, and the state legislators state that you're supposed to have objective standards, and I would say half of them are subjective, and I really don't think they apply. But that being said, I'll address them anyway, because I think we meet them whether they're subjective or objective. We're not here to pick a fight, we're just here to try and get this matter through so that we can go before the state building committee and hopefully get some relief there, which is going to be an uphill battle, but we're going to do our best. So with that being said, maybe I can bring Molly up here. We can just quickly run through those standards. Okay, here we go.
Good evening, Molly Titus from Decrete Engineering. So under the Coastal Resources Overlay Section 4.4, there's development standards. Number 1 being the proposed project will not interfere with public access or use or enjoyment of tidal waters. I would say we meet that criteria since we're on top of a wall and don't impede public access.
Oh, and before I just interrupt, I'm sorry. We almost were able to do this via administrative approval. However, we decided that if you look at it, we're on an angle, so if you're on the beach looking at it, this building is actually the closest point to the water feature, and therefore we had to come here. We couldn't do it administratively. So if this wasn't the closest point and the house was actually the closest point, then we could have gone and done this administratively. But since we're at the closest point, the shed's at the closest point to the coastal feature, that's why we couldn't do it administratively. So.
Yeah, the coastal feature is the retaining wall and
Right.
perhaps the corner.
Right,
so.
and it goes on the corner. So because of the corner, we lost out. So we had to come before the board. So I'm sorry. Go ahead.
Number 2, the proposed project will not degrade the aesthetic or recreational values of tidal waters or diminish the natural diversity. I think we can say that that is accurate. We're not impeding access or any sort of enjoyment of the area, and there was a structure there prior in the same location. Proposed project will not degrade existing water quality or adversely affect the circulation and flushing. It's sitting in the same footprint as the previous building. While the building area is larger, there was a concrete pad that shows on this plan large that sat in front of the shed structure. So really technically from a water quality standard, roof is clean and sidewalks are not. So this used to be a concrete pad which would have more adverse effects on water quality than the previous roof area. Number 4s will not increase volume or velocity of stormwater. Again, we have the same impervious area. The proposed project will not diminish the value of any shoreline features such as storm or hurricane buffer. It's in the existing location. Any filling, grading, excavating, or other land alteration will be minimum necessary to construct the proposed project. There was no grading performed, and the finished floor and pad area is the same as the previous building. The proposed project will not pose any threat to public health, public safety, or property. I would say a newly constructed building that is standing better than the previous version would certainly meet that criteria. And then the last one just goes into the criteria for requiring a permit to not work within the first 100 feet. So those are the standards.
Okay. Any questions from Molly?
Speak up, guys, if you have questions for Molly. Yeah, I have a general questions that have come up somewhere along. Who's responsible for pulling the building permit? This has been going on for years, hasn't it?
The contractor.
The contractor?
Yeah, generally speaking.
Who is the contractor?
I don't know. I honestly don't know. I tell you. I mean, I have nothing to hide.
Yeah.
I mean,
Okay.
bottom line is he didn't pull a permit.
Yeah.
Yeah, we
If
were
I
brought
do
in
that.
after when there was a problem.
Uh,
So.
Yeah.
Wait, and when you,
And if you look to the history, I mean, my client right now is in the process of putting a substantial addition onto the property, and he's pulling a permit. It's
Yeah.
a shed. I'm sure.
but is it the responsibility of the owner? Ultimately, it always is, but
Right.
it's the contractor who has
It's
to
the contractor,
pull
the
the
plumbers,
permit.
electricians, they're usually the ones that pull the permit. And they know, I mean, in this case, it was probably it was a framer. I mean, it was just framing work that was done. And,
And those numbers that were in our letter here back in July, this is 2021 and August of 2020, those letters of cease and desist, that goes back to then. Is it the same framer, the same builder, the same
Yeah, it
contractor?
got, I believe a cease and desist was issued after the building was already complete. I mean, honestly,
This is back in 2021.
yeah, I think the building was complete back then, and, it's complete, as far as I know, it's complete. Isn't it complete on the property? It's great.
It is complete on the property.
Yeah. So there's a picture right there. I showed you the one that was framed, that's the one I had, but it's complete. And then the cease and desist order was issued. I think somebody complained, dropped a dime, so to speak, and said,
Because they're back working again.
they're not working on the property.
I must be missing something.
They're not working right now.
Well, no, maybe not today, but that's not necessarily relevant.
They haven't worked since the cease and desist order was issued.
Yeah, yeah.
Right, but this has been dragged out for,
For 4 years? That's it.
well, I've been involved
2025, is it
2 years
21?
ago, the cease and desist. I mean, it was already up, so my client, quite
Yeah.
frankly, wasn't in a rush. I mean, what could he do? There's nothing he could do. What kind of brought it to a head is he wants to put an addition on his house, and so we had to work out that with Wayne, which we did, and Wayne now saw a path forward. We were coming before the board, then we're gonna go before the state building committee. So given that, I mean, at the end of the day, if we require to take it down, we're gonna take it down. That's really the bottom line.
So, go ahead, James.
I
I'm
have
distracting
a question.
everybody.
No,
Yeah, you did.
it's a good question. My question was regarding the CRMC cease and desist. You can't get a building permit without a recorded assent from CRMC. Do they need to get the CRMC issue resolved before we should even be considering this? Because if they can't get a CRMC assent and record it, we can never get to the point of issuing a building permit.
My experience before this board is it's always subject to CRMC approval. So you always get the approval from the board, but you always make it subject to CRMC approval.
So CMC takes the last bite of the apple.
Yeah.
Yes, they will not entertain an assent for a project unless the applicant can accurately fill out the letter request from the building official. And one of those items on the letter says that it has already received all town approvals and the 20-day appeal period has passed.
Second part of my question, in light of the recent westerly ruling that we discussed and will be discussing, does the voluntary demolition of the previous structure preclude the construction of a new one?
I can answer that. So I raised the issue last month on the foundation. The foundation is still there, so in my opinion, if you leave the foundation, that is not a complete demolition. Putting that aside, I also have tonight, it's the third item on the agenda, I'm seeking a text amendment to take that off the table. But I think keeping the foundation there does not constitute a complete demolition.
So, Mr. Grody, if I may, the foundation is part of the non-compliance that Mr. McGree and his applicant has to go to the state for, because it's not built in compliance, it's not on the correct foundation.
So does that have a bearing on our ability, like we had with, again, I'm very compassionate towards the attempt to correct what might be a unique judicial decision, but
I gave it another name.
I was trying to be kind, but I agree with your initial assessment. You know, does that limit us? Because this is substantially more than 50%, even whether the foundation stays or not. Is it considered new construction post 50%?
Well, I'll say this, let me just say this.
I'd rather hear from the solicitor what his opinion is.
Go ahead.
Hang on, Jack, you can weigh in after me. Taking it from the reality of where we are today going forward, I made my opinion known about the landfair decision, the subsequent affirming of it by the Supreme Court. Jack, I understand, has drafted an amendment to our zoning laws and ordinances that will correct that. How is it going to correct it? The Westerly decision was driven by their town ordinances and interpreting their town ordinances. Ours is very similar. We're going to change it so it's clearer and doesn't have that, what I believe is inappropriate impact on someone relying upon assurances, knocking a building down and then being told you can never build something there again. So if you have something else you want to add?
Now, I was just, I'm just bringing it up for the sake of bringing it up, is that statute, that was the state enabling legislation about objective criteria. So section 4.4 requires special use permit. You're supposed to have objective criteria. Tell me how, does the project degrade the existing water quality, or does it, will it be in harmony with the general purpose and the intent of the comprehensive plan? How is that objective? I don't think it's objective. I think half this ordinance is not in harmony with 45-24-12. And quite frankly, I don't really think we need to be here, because I think the statute, you don't have objective criteria for 4.4. Tell me if I'm wrong, but I don't think you do. There's a lot of stuff in section 12 that gives objective criteria. For example, more than 4 bedrooms, it spells out the number of parking spaces. That's black and white. This statute is as subjective as it gets. I mean, does it serve the public interest? Is that objective or is that subjective? I think it's subjective. Am I missing something? No, okay. So, I don't think I need to be here, but we're here because when I don't want to drag this thing out for a year.
Can we move along?
Yeah,
Sure,
that's-
Steve. But that's my most important point, really.
All right.
Fair
Gotcha.
enough. That
Okay,
sounds like judges and lawyers got to deal with,
I know.
I see where you're coming from.
Okay.
There's some subjectiveness there. So, you're on the same foundation, so you need relief from the building code because you're not on stilts. I'm sure your neighbors don't want you on stilts either. I don't blame you for not building it on stilts.
Right.
So, I'm not terribly worried about that. That's your fight with the state building code. You got to deal with CRMC. Obviously, they're going to be the biggest hurdle for you. To me, you're in the same place. You haven't increased the footprint impervious. I would like to see, I know you got a stop work order, so who knows what you were going to do. I don't see any gutters, so I don't know how you're going to control that stormwater when you go to CRMC. Just a thought. You might want to pitch them something, even if you recirculate that water I'm sure you're on town water there, I'm sure they got sprinklers. Be nice to capture some of that and use it to sprinkle the lawn. It helps the town, it helps the water system, and it makes CRMC happy. Just a thought that I have for you. But otherwise, I'm in favor of granting this because obviously you have many more hurdles to get to, and I don't want to hold you up here spending a bunch of money when you don't even know if you're gonna have to knock that down or not. So, that's where I'm at.
All right.
So I have
Yes,
a
sir.
question for Bob. So what's the order of procedure? I mean, he has to go to state building code. Do we have to make a decision on a special use permit before he goes to state building code, or should he go to state building code first? I mean, I see a
Well,
lot
you don't, in fundamental fairness, you don't want it to be a catch-22.
Yeah.
So any decision you make here would be subject to state building code and CRMC approval. So it would never mature into an enforceable decision unless he was able to get the approval or the assent from those two bodies.
Yeah. I mean, the things I see here, seems like the big issues are state building code.
Yes.
Mr. Friday,
Yeah.
section 4.7 in our ordinance is the special flood hazard overlay. So one of the requirements of the special use permit standards that Mr. Green, I don't believe he agrees with, is compliance with section 4 of the ordinance. So I had just asked Mr. Craven about how, speaking of catch-22, and or better yet, what comes first, the chicken or the egg? Does this application need to first receive relief so that way you can find compliance with section 4?
You can do that if you wish to. But I'm saying, I believe the state will then send him back here saying, we will not act upon it
I think that's what,
unless the town gives you
Yeah, well,
approval.
I don't want to do that.
I think
I
Wayne
wouldn't
went
wanna
back
do
and
that.
forth, and he finally landed on, I come here first before I go before the state building committee, because they may say, we're not gonna act on it until we get a decision from you.
Your discussion with Wayne?
Yeah.
Okay,
Yeah.
okay.
Then I would
Correct,
say,
because
then
I
I would say to
actually
you,
filed
Mr.
it.
Friday
You
and
did
the
file it
board,
with the
that
state
it should
building.
be conditioned, that any relief that you would recommend would be conditioned upon that approval. So you can, so when it matures, that it would be in compliance with section 4, whether it was denied at the building code, at the State Building Code Board of Appeals, or the variance was approved.
Molly had a conversation with Wayne, maybe you might wanna.
Yeah, so when I first spoke with Wayne, our original guidance was actually to file with state building to request the variance. And so we went on to the portal, we started filling out the application, and when you get to the end, there's a form that the building official needs to sign that says the town has reviewed this and
Similar to CRMC?
yes, exactly. At which point he said, we'll see you in zoning. So that is why we are here.
Fair enough, thank
You've
you.
been down that road.
Yes.
So, back to the slab. So, was the original slab removed, repoured? It's the original slab?
My understanding, it's the same location and the same elevation. Has it been replaced in kind? Based on the plan, maybe? I don't know. These are the architect's plans, I'm not. These are not.
That doesn't answer the
'Cause-
question.
'cause it
It's the
seems-
same slab, yeah.
Because it seems like that's a key issue.
So that says previously demolished concrete.
So,
Is that the portion of it, that front piece? That
The
was-
front piece,
I think
maybe?
the front piece
Is
may have
both?
been taken off, but not the entire slab.
well, points to both of them. Is location of previously demolished, one's shed, one previously demolished pad.
There's a division line though, a green line running down the center.
That's demolished shed, that's demolished slab.
Yes.
Yep.
So I think the slab portion was taken off in the front there, but not completely removed.
Yeah, it's possible the front piece didn't have a foundation, the building piece did.
Right, yeah, that's why they put that dotted line there.
So that appears to be unclear. Go ahead.
Yeah. Well, I think from the town's perspective, sort of compliance with the state building code, which apparently isn't in our hands, matters because of the discount of the state flood insurance that happens because we've been enforcing the FEMA regulations. So I think that's an important issue.
Does the town traditionally require a 128 if there was building without permits and inspections to relieve the building inspector of liability? Or do we normally grant the building inspector the right to ask for a 128 form if he's uncomfortable signing off on something he didn't oversee?
That's a good question, Mr. Groening. I'm not actually sure. I've never heard of a 128 form, so I don't believe we have one.
So it's a form where an engineer of record comes out and the engineer assumes the liability and responsibility for all construction. So they would be responsible for certifying.
Okay, thank you. So I will say that the previous building inspector, I believe Mr. Fermental, may do the same, is at the end of a project prior to CO, the building inspector would ask, I know the previous one did it, and I want to say Wayne does it, but I'm not sure, but the town has done it in the past, is my point. Requested that the engineer of record certify that all of the conditions of the decision have been met and that the project is built according to the plan. I will also tell you that that isn't always the case. And we currently have, just so for everyone's edification here, we are in the CRS rating program. I'm sure some of you know that. Mr. Rennie, I think your previous town was as well. We are a rating of 7, so it's a 15% discount. So every variance that is granted at the state has a potential to jeopardize the rating, which would hurt every property owner in town who has flood insurance, who's in the special flood hazard area. Getting back to the point about the 128, we are already in a situation where we have a potential variance being requested at the state through no fault of this board or the zoning board, and it had been reviewed by the town and reviewed by FEMA, and 7 years later was discovered to be an anomaly. And so we are already in a situation where we're going to be seeking, or that property owner will be seeking a variance. And it's concerning for the staff because there are, Amanda, how much money do we save?
260,000.
Yeah,
in total?
so, yeah. So, and that was in 2018. That was the most recent number we could pull up. FEMA was closed today when we tried to call them.
Can I ask a question on that?
Sure.
Just, I probably shouldn't, especially if you don't know the answer. Violating all sorts of rules. I'm gonna ask that anyway. This is a shed, it's not a house. And I know generally speaking, when it comes to insurance, flood zones, if you have, for a carpenter for example, if they have tools in a shed, it's not insured if you get flooded. So I'm not sure if that would have some impact on a shed. Would that adversely affect your standing? I don't think a shed would probably impact it, just because it's a shed and it's not covered by flood insurance anyway. So if you had tools in there or something like that, not covered. I know that from personal experience.
My concern is more the liability on the building inspector. If it were found, and I'm not going to make any accusation about the construction, it could be the best built structure in the town, but if the foundation faulted, if there was an electrical problem, something behind the wall that was concealed, an engineer would come out through their O&M insurance, they would certify that they did an inspection that they were comfortable with. And these are fairly common in commercial construction, they're less common in residential, but it removes the building inspector. He receives a completed 128. The liability goes on whatever engineer stamped it and signs its O&M, and that's accepted, and I believe the state building code gives the building inspector the option of utilizing that form instead of even doing inspections themselves.
I did call the architect this afternoon, and he said those plans were stamped, and an engineer did certify that foundation. I don't know if you have those plans available, but if not, we can provide one. They told me it was in fact certified and stamped by an engineer. Like the foundation could support that
I'm
structure.
just thinking, rather than you having a building inspector that wants you to open up walls so he can see every tie, every joist, every electrical connection, if you had a 128 and the board were to approve it, then it might move things along, and it also gives you an engineered stamp on the construction.
I'm sure we can get something like that. Like I said, it's not a house, it's a shed.
Move along here.
Could you go back to the, Amanda, could you go back, put the site plan up for a second, please?
Sure.
This is a fireplace. This is the property line, is that correct?
Yeah, that's actually a retaining wall. That's probably about 6 feet tall, 8 feet tall.
Isn't this the retaining wall?
Yes.
Yeah.
This is the property line right here?
Yes.
Coming right through the fireplace?
The blue.
Yeah, it's right here.
Yep.
Yeah.
Yep. Interesting. And I just, so I've got this. This was, I think what I heard you say, Jack, this was constructed and completed approximately 2021.
Right, that's mine, yep.
And the impetus for bringing it here to be legalized now is that the owner is seeking to construct an addition or something to the house now over there?
No.
That's the impetus for getting it here?
No, he was actually cited a couple of years ago. And I had reached out to Wayne a couple of years ago, but obviously, I mean, there was no, at some point I needed to do something. And what pushed the thing forward was that he went to apply for a building permit to put an addition onto his house. And Wayne said, okay, I gotta dust this file off, and we need to like have a path towards a solution towards this, and that's when Wayne had sent me the email saying you need to go do A, B, and C. And then once we said, okay, that's what we'll do, we finally got it. And then I believe, I don't know if he's issued a building permit yet, I'm unaware of that, but he's in the process of putting on an addition on that home. And Wayne was fine with that as long as we filed this application and we're going before the state building committee. But, I mean, we were prepared to address this a couple of years ago, but believe it or not, Wayne's a pretty busy guy with all those modifications he needs to do these days, so this wasn't a high priority for him. But it was kind of forced upon him when my client went to pull a building permit.
Okay. That's it for now, thanks. I'm done. I'm done.
So, any other summarial comments, Jack?
You know, that completes our presentation.
Yeah, my only comment, I already said, old school. The owner obviously is ultimately responsible for a building permit, but this is 4 years. It's like nothing. Whoever was the construction people, there's something missing here. You're in the building world. You get into something like this?
Well, I wouldn't, but I don't, you know.
Well, that brings up a good point. If the first, hopefully this isn't the same person you fired the first guy, right?
Again, I don't know who's doing the building.
Well, no,
I saw a
mean,
picture
if
of one guy in the roof. Is there a guy in the roof here?
Yes, there is.
Yeah. That's as close as I got to who's doing the building, is a framer on a roof.
Well, there ought to be some way to correct people who do things like this, and put you, and you're the owner of the property in this situation. I mean, the person, if they have a license to be a contractor, I mean, it's just, if this goes on here, it goes on again. Somebody else, it could be somebody in this room. If this person goes and works for them, they don't pull permits. And then, I mean, I don't understand that way of thinking. But in any case, that's my view of things. So, any other conversation?
I got one more question.
Tom?
If they move forward to pull a permit for this in 2021 or 2001, the construction, would there have been any different standards or regulations in place at that moment in time that would have precluded this from being built?
Mr. Kelly, and they are under the 2021 regulations.
Okay.
Mm-hmm.
Okay.
But as far as, are you referring to the floodplain?
Yes.
No, same floodplain.
Okay. Thank you.
Been the same floodplain since 2013.
Thank you.
So I guess we're ready for motion? We're over here, guys.
Seems that way. Anything else from staff? Anybody got anything over there? All right.
So the first is complete, I guess.
Yep. I move that this application is complete and in conformance with our comprehensive plan.
We have a second?
I'll second.
All those in favor?
Aye.
Aye.
Yes, okay. 5-0. Go ahead with the main motion.
Right? I would also move that we approve this application with staff's recommendation for contingency on CRMC and state building code variance request. Anything else? Do I need to make anything else, Tom? You usually know what's going on pretty good, buddy.
No, I think that's fine. I think that's fine. I think that's fine.
I do have one.
Yeah, you got anything, Jack?
Yeah, on the recommendations, there was a recommendation,
Yeah.
what was it?
Yeah.
Number 3, that the project must conform to the National Flood Insurance Program, state building code permit requirements. I would like to insert in there, subject to the variance, if any, granted by the State Building Code Committee.
Good catch. I actually have a question there next to that in my book. So actually,
Jack, is that the new report I gave you or the other one?
Oh, I
Because
don't
the new
know.
report reflects what you just said.
Does it?
Yeah.
Is it? Oh, you picked that up too?
All good.
oh, in the old one, it's not great.
The third,
Gotcha.
it's
Oh, yeah,
highlighted.
yeah.
The new one is number 4.
Yeah. Do you have the new, did they have the new staff report? You
Yes.
do? Okay.
Right.
Yeah, she amended it before tonight, so number C is in fact correct.
So, Steve, what I would, if you're asking, here's what I would recommend you consider. You know, I would say, let's adopt you recommend approval. Adopting the findings in the staff report dated December 10th, 2025, as amended. I don't know if what Jack just said causes you to make any further amendments or not?
Now, yeah, I would amend it. That's what I was trying to say, is that it would be pending state building code approval. So yeah, I would amend that, which is now the 4th condition in the new one.
No, there are
Or
currently
third.
6 conditions included in the staff report. Given what Mr. McGreen had stated earlier, I would recommend, if that's what you're interested in including, is adding that to the butt end of condition number 3, that the approval is contingent upon a variance being issued by the State Building Code Board of Appeals.
Yeah.
We also have the modification though to the National Flood Insurance Program.
Right, is that made? Is,
We get there.
I'm sorry, Mr. Grundy, are you saying on condition number 4?
And on condition number 4, there was a recommendation for added verbiage related to the National Flood Insurance Program.
Jack, that was you.
yes, no, I was just saying that we may not conform to the National Flood Insurance Program. So if we, it would be.
Well, you would conform with a variance, would you
Right,
not?
with the, right, so it would be tied in, the same language that's in number 3 should probably be added to number 4. You know, if we get the variance, then obviously we would have an exception to the National Flood Insurance Program, right? Just,
Well, it says our state building code requirements, so in theory, if the variance is granted, they'd be in compliance with that.
Right, so I would kick that to Mr. Caven right next to us, but the question,
as modified maybe, state building code requirements as modified?
we wouldn't have modified the building code.
No,
So,
not modification, but the relief that we're seeking at the state level.
right, hold on, I think I want to show.
I don't want to overlay everything. Too late.
There you go. Do you know where we are? Oh, you have the new one. So I think they want to add in some kind of modifier to that. I don't.
To section 4.
Yeah, I don't do it. But if you receive the variance, do we need to address the modification, or is receiving the variance complying?
Receiving the variance is compliant.
Okay.
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 And we'll add the conditional language in 3, as Mr. DePonte
Yeah.
said.
Excellent. I'm sorry. I hate to backtrack us, but I just had a thought, and I don't know. Should we be taking public comment on this, or do we not have to? Is there anybody from the public that wants to comment?
Very good.
I'm sorry.
Yes, but no, thank you. Yeah.
Is anybody? Are you guys here for this one? No? Okay. I just saw 2 people, and I was like, no, we didn't ask.
No, thank you.
Okay.
I apologize.
So I move that we approve with the conditions from the staff report from December 10th with condition 3 amended as discussed.
You looking for a second?
I am.
I'll give you a second.
I'll take it.
Okay, all those in favor?
Uh,
No. Abstain. And I don't want to go on the record a while.
Yeah, I'm negative.
Well, I abstain.
So we have 2 positives, 2 negatives, and an abstaining.
And I want to abstain because, Jack, but I'm convinced, but for the fact that he needed a building permit for the addition to the house, that this would have never come through, he would never pull the building permit. I simply can't encourage that behavior out there, so I'm going to abstain. So the motion fails?
Motion fails.
Motion fails?
Yeah, so 2-2 abstain. God bless America. No, you're always good, Jack. You don't always agree, but
It's gonna be.
moving right along. One of my cousins are coming up here next.
Dr. Arnell, it was very hard to keep writing this name over and over again without the apostrophe, capital N, and 2 L's.
Well, as everybody knows.
Did you want
And if-
Sorry,
and-
go ahead.
I'm just watching them all day. I don't know if they want another motion just to keep it clean.
On this,
It makes the decision.
that we
We
don't
don't have
have.
a big time of failed vote in
Okay.
that report.
Sorry,
I mean,
eavesdrop
that's
across the
what
room.
I
No,
said.
no, no.
Said that we should probably vote.
So are you up for the next one?
I am.
Oh, you're warmed up.
Jack.
All right, okay, we're warmed up over here. So, one of my distant cousin, because it's only 1 L, so.
And no apostrophe.
And no apostrophe. So, yeah, when everybody came through Ellis Island, wherever, the people scratching there, it made everything shorter. So a lot of people's names got narrowed down, but the real way to, no, I'm just kidding. So, we'll move on here to O'Neill, Plat D, Lot 230, 112 Caswell Street, and the summation of this, the applicant is submitting a request to construct an 8-foot by 30.5-foot covered front porch at the above referenced property. This requires a variance from the dimensional regulations. I think it's 8.5-foot front yard setback variance. Fire away, Jack.
Thank you, Mr. Chair. I ran out of ink when I was home. I do have one picture though.
You used to equal that. This guy.
Yeah, use that one first. But that is a picture of the corner of the property, just to show you the site plan. So, thank you, Mr. Chairman, again, Jack Green for the applicant, who is Tony O'Neill. Property is located at 112 Caswell Street, identified as lot 230 on Assessor Plat D. Lot's located in an R10 zone, has 12,535 square feet, and the proposed improvements consist of removing the front deck right here along, believe it or not, this is wooden, the wooden walkway in the front deck, replacing that with a roof entry and front porch. And basically, the applicant wants to use it, for, protection from the weather, the aesthetic look, and also to be able to sit there in the summer. He's already, I think, about 3 feet within the setback, so he's looking for a total of 5.5 feet of relief. I mean, a total of 8.5 feet of relief, which would require an additional 5.5 from where he is right now. Other than that, I do have John Virgilio here, who's the contractor, to answer any questions concerning the design and the dimensions of the property. If you notice, though, I think your biggest concern would be, since it is on a corner, if there would be any sightline issues with people approaching that corner and trying to take a turn. It is an open porch, and if you look at that picture, you can see it's pretty open, and the trees are cut back along the side here, so I don't think it would be an issue for any sightline issues relative to the front porch. Personally, it looks pretty good. If you go to the site, the elevation plans, if you have those, you can see kind of a before and after look. Yeah, this one's actually a little bit better. I don't really have that, but you can see the before and after looks there on that colored paper.
I think we've gotten.
Yeah.
have this in our packet also, right?
And so, other than that, that's our request. You know, and just quickly, I'd argue that asking for a front porch to get, you know, to avoid getting rained on, and to be able to sit on the front porch if we were to get that, that would probably amount to more than a mere inconvenience for the full enjoyment and use of this property.
What do you think, James?
I think the fact that it's already gone through historical and been well vetted there, I think
I don't think,
That's for the hot tub.
It hasn't gone through there yet.
Yeah.
Oh, that hasn't gone through?
No.
I thought I saw in here that it had a...
something in the back,
That's for the hot tub.
Oh.
Yeah, which I didn't see,
a
so.
historic hot tub, that's interesting.
Yeah. It's got a wood stove.
No, I still think...
It's like a big barrel, they pour hot water in the bucket.
They did that.
Yeah.
Yeah.
I thought it had a historic for the porch.
I thought it, I read it 3 times.
I mean, I drove through the neighborhood, I don't see where it had any adverse effect. It appears some of the other houses in the immediate area are actually closer to the relief that they're asking for, so I didn't see anything.
How about
Yeah,
you?
I agree, I drove through too, I actually counted the houses on the street, there's 3 that don't have covered porches, there's 8 or 9 that do. Of the 3 that don't, one of them's a carriage house, it doesn't even have a front door. So it's definitely, you know, in character with the neighborhood. I don't see any adverse problems, there's quite a few houses closer to the road than this even would be otherwise. And I came up with this only getting 3 feet closer to the road, because you've already got a 5-foot deck there.
Right.
So it's really, it's not that much to let somebody sit under a porch and not get rained on. I'm in favor.
I thought maybe it was new math.
I do something.
How about you?
Yeah, so Amanda, I had put up the picture so you could see the house, 2 houses up from it's pretty close to the front rows. And I think the front porch is probably pretty consistent with that frontage. And I think it fits in with the character of the neighborhood, so we'll let the historic folks talk about the historic stuff.
So if we go ahead with, on a positive note, we would be with that addendum to the motion, right? Would be with the approval.
Historic,
So-
yeah.
It's
already in the staff
Go ahead,
report.
Tom.
Oh, it's already in the staff report.
It's already in the
Yeah.
So I don't have any questions with respect to this one.
Yeah, the only thing I would say, well, first of all, compliment you in terms of the corner and the vision in terms of driving. We have people come before us here, and they swear when they're leaving, they're gonna take care of, you know, they got some obstruction, they don't do it. Because I go and look, and I like to be heard. I can't believe that, you know, these people drive cars, obviously. So thank you for that. The one thing I would ask whoever does a proposal, that this is a permanently open porch. In my many years of driving around here, looking at porches, many of them now are part of the house or what do they call them, sunrooms, and they're no longer used as porch, and they lose that appearance. And I don't know if the historic people support this, if they use that phraseology that this has to stay open in order to give it that historic flavor. You know?
That may violate the FAR issues. If it's closed, then FAR would kick in, I believe. Flooding ratio, would that kick in?
It would.
Yeah, it would. So I'm not sure if that,
That's done on a weekend, and you know, so unless somebody files a complaint, it never comes back here. So it's just, if whoever does the motion, if they would add the permanent openness to the porch.
Would you be okay with that
Yeah, not a problem.
condition?
Yeah.
So with that, if there is any comments?
Thank you. Oh, are you the architect?
No,
He's a builder, John Virgilio.
Oh, you're the builder.
Virgilio
Okay.
Builders.
All right, John.
we're going to get a permit.
And you already have a permit?
Yeah.
You should be employed. Okay, so I guess we need a motion?
Mr. Chairman, I move that the motion before us is complete and consistent with the comprehensive plan.
Second?
Second.
Okay, all in favor?
Aye.
Aye.
And I move that the project before us 112 Caswell Street, tax assessors, Plat D, lot
Yeah.
230, affirmatively with the conditions in the staff report of December 10th, and 2 additional conditions. One, receive an approval from the Historic District Commission, and the second, that the courts remain open and not closed.
Second?
Second. Take your time.
Tom, second. There you go. Okay, all in favor?
Aye.
Thank you, Mr.
How easy that was. I know. Thank you. We'll move right along.
He's not going away tonight.
I had our
likes
last
it.
item.
Whipping along here.
He likes it.
So this is a referral to the planning board, a application for zoning ordinance amendment. Section 9.1, whatever that means, 2. Number 2, non-conforming uses and structures continuance. Applicant is Martino.
So, thank you, Dr.
Wanna
Neal.
explain?
Mhm. Absolutely. So Jack Green is the attorney for the applicant who's requesting the text amendment to the zoning ordinance. The section, I think it's sections 19 and 20 of your ordinance, put the planning department as the agency who receives the applications, and then it requires that we must immediately transfer or send those applications to the town council and to the planning board. So if you were watching last night at all, you saw there was a referral on the town council agenda where I referred it up to them, and then turns out they referred it back down to you. But today, fulfilling the other half of that duty as the planning department, we are referring it to you directly. We have not reviewed this application, so we're not going to go over the merits of it today. I don't have a report for it. I just received it the middle of last week. There is a 45-day timeline for this project, which started on December 9th. That puts the deadline for this board to have make a recommendation by January 22nd. That being said, the next regular meeting you have is January 21st, which does not allow you, primarily, I don't believe, enough time to review the application, its merits, in case you wanted to discuss it over one more meeting, and not just one meeting, 2 meetings. So I am asking that the board triage their schedules to have a potential special meeting date on, I prefer January 12th or 14th, but we could go to January 8th as well.
Unless the applicant wanted to
Unless the
provide
applicant...
some grace.
Well, right, I haven't received that grace as of yet, so I'd like to...
I just wanted to raise it publicly, that's all.
Unfortunately, my client's not here, so I'm not in the position to say yes or no. Personally, I would, but my client has been waiting. She's already continued her zoning application twice. She wants to be in her house this summer, so I can call. Do you need to officially do it tonight, or no?
I don't need to do it this evening,
Okay, all right. I can just...
but it would need to be, so those dates, the staff came up with those dates because those are the only other dates where we don't have meetings and rooms are available.
So Joe, what date would you like?
I prefer the 12th or the 14th because it gives me an extra few days.
12th of January?
So January 12th, which is I believe Monday or Wednesday.
It's a Monday.
Monday.
The 12th is a Monday, or Wednesday is the 14th.
Okay, as opposed to...
As opposed to the 8th, which is the Thursday before.
That's, you know what, I'm gonna go out on a limb. I'm gonna go with the 12th or the 14th.
Wow, thanks, Jack.
Do they work for you, both of those days? You
You
can
know
be
what?
there?
So, I'm sure they do. I don't go anywhere.
I can't imagine us not having some questions for you.
Well, it's pretty straightforward. 12, 14. North Province on the 14th.
12 is good.
So the 12th would be better for me. 12.
Is that a Monday?
Yes.
That is a Monday. Getting my hair cut at 3 o'clock, so I'll have a brand new haircut. 12.
Good time, Jill? Do you prefer?
6 o'clock.
Okay, just making sure, I don't want to.
Yeah, no, thank you, thank
I'm
you.
not great at that.
Good.
It would be a public meeting, yes, so thank you, Ray, it would either be you or maybe Isaac.
Okay.
So do we need anything further on this item?
Did we confer? It could be the 12th, or do you want us to follow up with an email?
I mean, we have a special meeting on the 12th.
Okay, great.
Review this, that'll post it.
Okay.
Cool. Do we need a second? Do we need a decision?
Do we need a,
Do we need a decision?
do we need a decision?
Do you need a motion to
Motion
continue?
on-
I don't
No.
think you
On-
need a
on a
motion. No. This was just a referral, so
Yeah.
there's really no there's no voting necessary. You
Okay.
told me by consensus you're available on January 12th.
So January 12th. Monday, 6 p.m. Okay. Moving right along. We're on to recommendations to town council.
Thank you, Jack. Thank you.
Recommendations to town council, zoning ordinance amendment. Reversion to dimensional regulations prior to December 18th, 2023, specifically sections 2, 4, 6, 7, 12, and 17. I remember them well. So, Jill, where are we on the
Sure.
journey?
So, I think in the report I gave you a timeline of what had happened, but for those of you who may not remember because it was a whirlwind, we weren't here. The town council referred to this board what we affectionately refer to as the 14 amendments back in, I think that was February of 25, and they gave us all 13 zoning ordinance chunks and a comprehensive plan amendment. We're going to fast forward. You had 6 meetings. This board had 6 meetings on all of those. You made your 45-day deadline. Good job. And it went to the town council on May 5th and May 14th or May 15th? May 14th. Ultimately, the town council withdrew. I think there was a lot of concern from this board. I don't need to reiterate for you. You have the 31-page report in front of you. And you talked about it for 6 meetings. And when they withdrew, they asked, they indicated at the time that they wanted to have work sessions, and they did. So at least these 2 items. So on August 6th, there was a work session where you discussed a variety of things with them, and one of them was this 15% modification. So I rewatched, I relived all of those meetings, and I tried to synthesize down what some of the bigger concerns that the council had. I'm going to put them in the front of your report to address. And we are now back here. They gave us smaller chunks to deal with, so it's just the 15% modification, of which the council had said it was just the straight reversion back to the 2023 regulations. There is an additional sentence included in there. I don't know what it means. I apologize. I did ask legal. I haven't heard back yet, but we have Mr. Craven here today. Maybe we can get to that. But that's where we are. So if you don't mind, I'd like to go through all of that, and then if Dr. Neal, if it's your pleasure or the board's pleasure, you can do. I can't see that. Dang it. We could do one of 2 things. You can either let me talk for the entire time, or you can stop me with questions. It probably would be better if I just kind of got through it, and then we can go back as necessary. Thank you very much, Heidi. We could go back as necessary, but I'll start, and then you can determine how you want to progress. Okay, so that looks cut off at the top, but there we go. So. Yep, so I think that says something about it. So the first thing I just wanted to go through is this is the law as is. The last time you saw this back in the spring, I think it was a strikeout underline. It might have been a year ago, a strikeout underline. So this is it. This is it now. It's in the state law. It's in around general laws, and it's here. So for substandard lots, right here under 45, 24, 38, it talks about the minimum building setbacks, lot frontage, and width requirements for a lot that's non-conforming an area shall be reduced by that same proportion of the area as the substandard lot meets the minimum lot area. So if you are a 6,000 square foot lot in an R10 zone, you're 40% deficient, you get 4 feet off of your side yard setback, or your, if it was 10, and then it also says in the second part, which is very difficult to read, that if the town has a zoning district in which the lot could be conforming, the town may require the compliance with that setback. So if you had an 11,000 square foot lot, we'll say in an R20 zone, then instead of doing the proportional differential there, you could say this lot will comply with the R10 zoning dimensional regulations. We're going to move on to the next one. Okay, that one's on. There we go. Okay, thank you. And again, for the building coverage for lots that are non-conforming, it talks about that it's the increase by the inverse proportion of such a substandard lot meets the minimum requirement. The interesting thing about this one is it doesn't then give you the caveat of the underlying of a zone that you might comply. It simply says that you get the inverse proportion. So if you are, I believe the example I used in your report is if you're an 8,000 square foot lot in an R80 zone, you're 90% deficient. Your lot coverage would have been under these new old and maybe once again new regulations. Your maximum lot coverage would be 10% plus the 90% deficiency, so that would be an additional 9%. So 90% of 10% is 9%, and so your new allowed lot coverage would be 19%. Well, there's some hang-ups with that. I'm sure we'll talk about that. And just for the record, we had a really great substandard lot of records section 6.5, which would have allowed 25% in a lot like of this case. So this state law actually may have hurt lot area applicants trying to build, because this lot would have otherwise been 25%. Just want to say that. Okay, so in the modification, so in addition to that substandard area that I just gave you, you can, once you get your side yard or your setbacks based on your substandard lot of record, you can then apply for a modification. So you can get an additional 15%. I want to just refer to the notes in here because I did give you an example and I thought it was pretty helpful. So in that same example of an R80 zone, an 8,000 square foot lot, which is not a small lot, by the way, there are much smaller lots in town. That front yard setback with the substandard lot of record would have gone from 50 feet. These are under the new proposed regulations, 50 feet to 5 feet, and then with the dimensional modification to 4.25 feet. The side yard would go from 40 feet to 4 feet, and then 3.4 feet with that dimensional modification. Rear yard down to 5.1 feet, and then, as I mentioned, your lot coverage allowance. So, actually, I think I have that number wrong there. I'm going to check that one. I think that should be 19%.
That number you gave was 3.4?
Yeah, side yard setback. Yes, Dr. O'Neill. So we'll talk about that as well, because we do, as this board unanimous, minus Mr. Grundy, as this board unanimously came to consensus back in March or April in that 6 meeting time frame, that you were in unanimous support for a minimum side yard setback for health and safety purposes. And in fact, that is it is provision number 1 in the zoning enabling. So the general health, safety, and welfare. And I believe I referred to that in your letter.
Right.
So, okay, so that's where we are. Okay, great. So this is the modification, right? So if it's a modification of 5% or less, then the zoning enforcement officer, Mr. Pimentel, he has the authority to issue a permit outright. From 5%, the town could have gone up to 25%. This board recommended and the town council approved a 15%. So from 5.1% to 15%, it's a modification which it requires the abutter notification and an ad in the newspaper. And then we just talked about here, so it's a 14-day. It does require both, is what I would like to point out. It's not just the immediate butters. There's a requirement to put it in the paper still. That was not eliminated even after they made a second round of changes to this at the state level. The one thing I want to point out here, it's in gray at the bottom because I didn't want to not show it, but we're not going to discuss it tonight. So I didn't want you to think I was purposely omitting a section of the modification in the state law. But we're not going to talk about it today because it's not germane to this report, this proposal in front of you, but it will come up when we talk about bringing forward the text amendments for you for compliance with the 2025, the changes that just occurred. And that's the neighborhood character-based modification. I have it at the very end if you want to discuss it, but it's not germane, so I didn't want to confuse the situation. Okay, so the proposed ordinance. So as I mentioned earlier, and I apologize, this is really tiny, you do have it in front of you and you should have it in color, that the town council indicated that they were simply trying to revert back to the 2023 regulations, save the height. They did not recommend any changes to the height for main structures, so they did leave that at 30 feet. The text language that I'm not sure, give me just a second, let me just grab it. It's right there at the bottom of the first page. So part 2, which is changes to section 4.5 and the high water table limitations overlay district. So for those of you that are aware, we have a high water table limitations overlay district which regulates site coverage or impervious surface coverage and what the town council is proposing is to change that site coverage back. It's right there on the table. You can see it. Something out here. Oh, maybe I got one here. Oh, there we go. Right here. But then there's this additional sentence at the bottom that I am unclear of the purpose of. Maybe, and as I mentioned a minute ago, that we do have legal here, or maybe we want to give them a chance to review it and come back to you next week. And now is probably a good time to tell you, you do have a special meeting on this on December 22nd. We did poll you. You're all coming. All right.
Everybody knows that, right?
For those out there who might be watching. So that says the maximum lot coverage in legally created dimensionally substandard lots of record shall be determined consistent with this section and applicable state law for substandard lots of record.
What does that mean?
So,
I don't know.
So can we stop there for 1 second?
Yes.
Doc, can we stop there for 1 second? Jack, so what I'm curious about is this is placed in section 4.5, but it can either be read as to be limited to section 4.5, or it can be read with the words maximum lot coverage, which may be a defined term somewhere else in the ordinance, to apply to the entire, to any substandard lot of record. Now that's what we're trying to figure out. You have an opinion? Bob, do you have an opinion?
It's confusing to me as it is to you.
The way I read it, it seems to me that the intent is for it to apply to any substandard lot, whether or not it's in a high water overlay district or not.
I would say that that is a reasonable interpretation, but when you're doing something like this, I think you ought to be clear and specific.
So is that something that we can get
Yeah.
an answer for Monday?
Next week.
Great, thanks.
Great.
I'm sorry.
No problem. Do you want me to continue? Okay, great. So if we move on. Oh, nope. I'm sorry, Amanda, can you go back one more? Thank you. So part 3 right there, which is our changes to...
I'm sorry, let me interrupt just one more time. And Bob, one of the reasons why this is of interest, not only in terms of the substance of the answer, but this has been represented by the council to be essentially a reversion. This is simply a reversion to where we were. And what we need to be able to understand is whether the language that's added here is consistent with what they're trying to do.
I
Because
get
it may or may not be, and it may or may not be what they intended to do.
Well, we have to define the word reversion in its history.
Exactly, exactly. Okay, I'm sorry.
No problem. Okay, so part 3 is the actually the changes to the Breakwater Village Special District. I can see we have at least one person in the audience here from Breakwater. And we were contacted, and actually just today, I received the legal request. I just received this. I'm still looking for it. Breakwater Village's attorney sent a letter to our attorneys. They sent me the letter today, requesting an additional change. Asking for an additional change. Well, first, the folks at Breakwater Village were reaching out because they wanted to make sure that this draft included any dimensional regulation changes. I did. Let me rephrase. I did hear from one person in the Breakwater Village. I believe she was representing the whole village. I haven't heard from the whole village on that portion yet. But the short answer is, the changes to the dimensional regulations for Breakwater Village are before you today. So that was the question. They wanted to make sure they were before you, and in fact they are. It is right here in part 3. The other request that I received today from Harrison Law was a change to the shed setbacks. So in essence, the Breakwater Village shed setback says a shed can be can have essentially a 1/3 discount, where our regular up to 50 feet, where in our regular for the rest of the town, the ordinance reads you can put your shed up to 1/3, so you get the 2/3 setback on your shed. So they're asking for their ordinance to reflect what the entire ordinance says. I did ask Mr. Craven earlier today. I asked actually all 3 attorneys earlier today, and Bob just a few minutes ago, about how to address that since it didn't come from the council. So I think the response, and Bob can correct me if I'm wrong, was that in your deliberations and your discussions, when you are putting together your considerations to the town council, you can either address that as something that they might want to consider to make the change to or not. So I just wanted to get that out there, so that way Breakwater Village knows that we heard them, and you can incorporate that as part of your discussion if you like.
So, just to be clear, so did the attorney ask for the reversion of the other standards, or is there anything official from the village
I have,
association
yes.
or their building?
So I have a whole email correspondence which I was going to print out and give to you, but it was 8 pages long, and it spans like the last 6 months, because when the town council had originally given this to the board back in the spring, the association was concerned because they hadn't reviewed it. You folks discussed it. I know you said no one in the village came and asked for this, so this was confusing for you. And I know one of the concerns of the board at the time was that, particularly in Breakwater Village, that the setbacks become really constrained. So yeah, it wasn't addressed. It was addressed by this board at that time as recommending denial of the changes at the time, because they hadn't heard from anyone. That being said, like I said, I did have an email. I reached back out because I believe Mr. Durkin at the council meeting, whenever this was introduced, November 17th, mentioned that someone from Breakwater Village had reached out, and I did receive that correspondence. I reached out to her. Her name is Linda. I reached out to her. We've had a little bit of correspondence back and forth, but I don't have anything from their attorney on it or anything on Breakwater Village letterhead. I just it was just a real good, and I believe Mr. Badano, who's in the audience, correct? Yeah, it was also at least in a portion of that correspondence.
Okay.
Yeah, Linda couldn't make it tonight, so I jumped in last minute.
I think it was Mr. Colonies and not Mr. Durkin.
I think it was both of them,
It was
actually.
Colonies to Durkin, and then Durkin, because he mentioned.
Yeah, so I received the email from Mr. Durkin.
Right.
Yeah. Okay.
Email come to Durkin.
So if we just, without discussing the merits, we're just gonna move on for a minute. We're gonna go to the next one, which is part 4. Again, the Breakwater Village, so it brings the side yard setbacks for on Follett, which, you know, which has its own regulations, and then 2-story structures, brings that back, the GFA, and the sun deck allowance, which, I'm sure you're familiar with in Breakwater Village. A lot of this is going to look familiar because you've read about it and or you were here when it went through. Part 5 is section 4.8.2, which is the Porto Galli Special District. So again, it's that reversion back, which is in the lower. So just for everyone at home, right here, this is where we are. And then part 6, special planning districts. This is the PRD, which is the planned residential development. So it's essentially like a floating zone. We have at least 2 of them in town. One since I've been here, up in the north end. It's called the Shore Club, and they have their own dimensional regulations right here. And so this is the town council is proposing to roll those back to pre-2024. And then section 6.4. There we go. So section 6.4, you're going to see this column right here where they did, where the council is proposing not to touch height of the main structure. So that does still say 30 all the way down. But they are proposing to roll back those other dimensional components for R80, R40, R20, R10, and R10A, and as well as the business and industrial zones.
I thought it was 29,
What?
the height.
30. Pardon me 1 second, I just want to make a note to myself. I need to look at something, and I'll have the answer for you next week, if there's a discrepancy for structures less than, structures without a 412 pitch. Okay, so we should be on part 6. We go back one more. Thank you. Okay, so right here, yeah, oh, so there we are, the A, the business and industrial zones, thank you. And then right at the, yep, keep going, so the bottom of your page, but I clipped it so it looks like at the top of the next page. So we're at the bottom of page 6 if you're following along in paper. And this is section 6.4B, which you may recall were some of the changes that were made as part of the bulk regulations in 2021 and then revised again in 2022. This gets us to FA, one more? Thank you, Amanda. Yep. There, no, thank you. This is the FAR. So, unlike what was, as I recall, what was suggested in March, they are. This suggestion is to roll it back and not eliminate it. So this is the rolling back, and then in part 9, part 8. I feel like my report is skipping 9.
It's up on top, dude.
7 to top of 8.
I don't have a page 7.
There you go. Page 7.
Shocking. Thank you, but I was smart enough to put it in there. So again, this is section 7.31, which actually refers to the hardscape and the softscape requirement. That's right here, the hardscape and softscape requirement. And then if we go down to part 10, this is rolling back for the supplementary zoning for accessory structures. So somewhere in here, I just want to see if I can grab that. I don't see the notation about the 50 foot, but I believe what they're referring to is that accessory building or structure greater than, again, Breakwater Village. I'm sorry, Breakwater Village. I'm jumping around just a little bit here, so it's right here. structures of, right there, so at the top, accessory structures not greater than 144 square feet, shall be set back at least equal to 1/3 of the side yard. So that's where you get, if your side yard setback is 12 feet, you get to go to 4. Where in Breakwater Village, if your side yard is 12 feet, you only get to go to 8. Did I have that wrong, Mr. Bonanno?
It's always confusing, but yes,
Did I have it wrong or right?
right, I believe.
Thank you. Okay, so if we go on to section, part 11. This is in section 12, which is special use permits. Looks like the maximum coverage for principal uses shall not exceed 30%. And I believe section 12:6, and let me grab an ordinance in front of, what is this ordinance? Thank you. Because they didn't give the heading to it, and I just want to make sure you have the right heading. Which are industrial development standards. So that's not clear here, but that would be the industrial, and that for everyone watching at home is right here. This 1263 is industrial development standards. All right. And then under part 12, so these, nursing, convalescent homes, group homes, things like that, there's some changes here. Oh, there's my page 7. All right, we're at 12:13. All right, so that's a motel and tourist courts. So again, this is just a real basic rollback. 14 is residential cluster development, so you can see that right here. So we do have setbacks very similar. I just want to point out very similar to the old R10 zoning. So R10 would have been 25 front, 10 side, and 20 rear. So that's a rollback right there, and then we're getting real close. Promise. And then part 15. So if we go to part 15, which is multifamily, it's a rollback there. So that was for the 50% modification. The other thing that the town council gave to you as part of this referral is a specific change to that section 6.5, which this board recommended and the previous town council approved based on health and safety. And at that time, as in April, you may recall, you heard from 2 firemen who were very concerned about the health and safety as well. And back in 24, the town council, late 23, the town council approved, in no case shall the side yard setback be less than 5 feet for a 1 or 2 story building, or 8 feet for a 3-story building without first receiving a variance. That, and again, for the folks who weren't here, because there's at least 2, maybe 3 of you who weren't here when that occurred, those setbacks were mirrored after 2 things. One, the 5 foot for 1 and 2 stories is identical to what Breakwater Village is. So Breakwater Village is, there are only 2-story dwellings allowed. You can't. I'm sure there's an exception to the rule, but right now the ordinance allows for 1 and 2-story structures only, and the minimum setback is 5 feet. The previous modified dimensional setbacks, as I mentioned when I started off, saying we had a really great ordinance which would have allowed smaller lots in smaller substandard lots to still be compliant and be comporting with other lots of the same size. That side yard setback for those smaller lots, 5, 8,000 square feet, 10, maybe even 10 in some areas, would have been no less than 8 feet for a 3-story structure, because 35 feet is about 3 stories. So when this board made that recommendation, and then more of this board back in April unanimously supported it, that was the logic behind it. behind those numbers, the 5 and 8, I should say. Okay, so if we move on, I took, and actually Ryan did the upcoming maps, which I hope can sort of relay that message that we had talked about, that I talked about in my report. Grab that report back, which, a lot of paper happening over here, I apologize. Is that it? Oh, that is it, thank you. Okay, so that example, so this one is all R10 parcels. So we took a look at all of the R10 parcels that are less than 5,000 square feet, less than 6,100 square feet. And for the record, I chose 6,100 square feet because a lot of these neighborhoods are, when they were originally platted, they were platted at 6,000 square foot lots or thereabouts. But sometimes those lots are 6,002 or 6,010. And I wanted to be able to capture those, so I went to 6,100. Just we do have the number for 6,000 if you wanted to see it. But I just grabbed 6,100 just so you could see it. And then all lots in an R10 and R10A zone that are less than 10,000 square feet. I bring this to your attention because these are substandard lots of record that will automatically get the, in the case of a 6,000 square foot lot, will automatically go to a 6-foot side yard setback. In the case of a 5,000 square foot lot, will automatically go to a 5,000 or a 5-foot side yard setback under these, and then that's without the modification. So it's a little bit, and then you add that on, if you take that example of 25% allowance for lot coverage, and then if you add on another 50% to that, you get up to 32 and change. So I'm just pointing out to you how many hundreds of lots there are. So if we go on to R20, same thing, we have lots of less than 10, lots of less than 20. And these maps might look familiar, by the way. I've showed them to you multiple times. They just keep changing, not changing the numbers, but pulling off what we need, what isn't relevant anymore. And then same thing with R40 and R80, same thing again. So we pulled out the 10, 20, 30, and 40, and then we broke it down. If you guys want a copy of this, I can give you a copy of it. But the last map I just want to show, thank you, Ryan, is these are all residential parcels that are less than 10,000 square feet. So they're either less. So the reason why I call this map out is because there are lots less than 10,000 square feet in other residential zones besides R10, R20, R40, R80. And I wanted to just give you a visual idea of what those substandard lots look like in our town. And that actually works out to that number. There we go. So it's roughly about 36% of all the residential lots in town are less than 10,000 square feet, and there's about just over 600, about 635, give or take. We're trying to manipulate GIS. We have some lots that are in the Chafee Preserve, so you can actually see them up there. That big, thank you. Those big blotch of black lots. We didn't pull them out of the map, but they're not in the numbers because most of them are the Chafee Wildlife Preserve. So we kind of left them there visually because it was difficult to pull out at the last minute, but I didn't put them in the calculation. So we have about 635 lots that are less than 5,000 square feet in area. All right. So as you see in the report, I did not, I could not, frankly, I could not offer you anything other than what you have already done twice. When you initially, and I say you as the board, when you initially made the recommendation in 2023, and then in the spring of this year in that 31-page report where you thoroughly went through every single change, and I tried to call out only the section headings and that were relevant to this. I cannot offer you anything else, so what I would suggest is that we have a conversation, you know, as the board, and then if you come to the same or similar conclusions if there are things you want to change, if you've looked through the comprehensive plan, all of that is on the table. And hence, that's one of the reasons why I polled you for a second meeting, because I didn't think we'd get through it all today. I certainly am not going to be able to take all the notes today and get it all for you, and I want to be able to give it back to you, for everyone to read and review the report that goes to council. And that's it. Thank you for letting me finish.
No, you did very well. So that's the meeting that we have coming up on the 22nd.
The meeting that you have coming up next Monday, the
Digest,
week of
ruminate,
the week of Christmas.
discuss.
Yeah. So we can discuss today. If we can get everything out that you want to get out, I'm going to take it all in. I'll relive this video this weekend, and then I will draft it for you so that on Monday, very similar, Dr. O'Neill, to what we did in April, where I pulled everything together, and then we had that one additional meeting where we went through the report. I want to make sure, that I have it all together for you.
Right. I don't know, the person who's here from
Nick.
Breakwater Village, yeah. I'd like to hear your perspective on this because...
Come up to the podium so that if there are any viewers watching us, they can...
In my perspective on this, so in the, I don't know, 2 years I've been on the board, what I notice about Breakwater Village is we see every project in Breakwater Village because the special use permit requirement for second floor or greater than 20% expansion.
Yes.
So we see every one. And my experience is that every project comes in building to the lines that are permitted.
Yes.
So if you allowed a 15% modification, everything would be 15% in each direction and 15% bigger.
Back to the original from a couple of years ago, right?
So it would go back to the original setbacks, but what Mr. Friday's talking about is the state law now requires municipalities to allow a modification. So your setbacks would go back to 5 feet, but then someone could come in and receive dimensional modification to go to 4.25. Someone could come in and receive an FAR modification, no.
A 15%.
Yeah, a 15% increase.
In the standard for modification, it's practically impossible to say no to it. And in the experience of the town since it's been adopted, there've been 64 applications, 61 were approved automatically, 3 received objections, and that was before the objection standard changed. And eventually all 64, 100% were approved.
So we'd have even less of a setback.
Yeah, 15% less.
And no control.
Mr. Chairman, or Mr. Vice Chairman, can I get his name for the
Oh.
record, please?
Sure. Nicholas Budano.
Thank you.
Thanks.
So they'd be able to override this, they could override and expand it.
Not to stay, the property owner asking for a building permit.
Okay.
Right, so Mr. Budano, so instead of 5 feet,
Yeah,
your
3.
neighbors could come in and ask for 4.25 on each side.
Okay. They could take advantage of the 15% from the state.
Yes.
That's still going to be in existence.
It's in existence now, but when the planning board and the town, let me just say the town council rolled back and put that 15% modification in place, what it did for Breakwater Village was it said, okay, you're going to go back to 6 feet, but applicants will come in and ask for that 15%, which will bring them right back to the 5 feet.
Yeah.
Right, so it was almost status quo in your neighborhood. That was, right?
Yeah.
Yeah.
I guess one concern is the state isn't going to be changing your setbacks, right? You're reverting back to the original, possibly.
Well, that's
the
the discussion on the table.
And
Will
so,
the 15% still be there from the inspector? Can you
Yeah.
get back to us? That'll always stay.
Yeah, unless the state changes it.
I can take it back to the board, back to Linda.
because when I heard the concern, it was like, when we did this originally, it was like in Breakwater Village, it's where it hits,
Yes.
matters the most of anywhere in town, I think.
Yeah.
But
So the board is aware, Breakwater Village has very small lots, right? They go from
Yeah.
like 1,200 to, I think some of their bigger lots are 10,000 square feet. But Breakwater Village is its own zoning district, so those lots are not considered substandard, like we just went
Right.
through. Just for everyone's clarification, they're not considered substandard lots of record. In the special district, each of the lot areas have been broken down into ranges, and then the setbacks are based on those ranges. So the bigger the lot, the bigger the setback. Most of the lots in that that you see coming through have that minimum 5 lot side yard setback.
I'll take that back to the
Okay.
board.
And I guess,
Yeah, I'm not sure if maybe Linda realized.
I think you were on that email where I
Yeah.
reached out to Linda, because I went back to May with Ernie and whatnot on that conversation, and offered, and you're welcome to come in if you want to come in and talk to me,
Okay.
and we can go through it. We have a meeting next week, so hopefully we can get it done before then.
and
We'll talk tomorrow.
And the other observation is, I looked at data for the past 5 years of stuff that came through the planning board and the zoning board, and of all the applications that came through us in the past 5 years, 15% of the projects are from Breakwater Village. So a really high proportion. It's because of that requirement that they come in for a second story.
The second story, yeah.
So.
Thank you. Any other questions?
So it seems like you're not sure whether or not the Breakwater Association wants the changes reverted to pre-2023.
We're trying to stay in line with the town. It's a lot easier, but I'm not sure. I'll talk to the board if we're aware that they could actually expand to over that, like the 5 foot, and go to like a 4 change. They can use that state 15%. I'm not sure if we had realized that. I'll talk to Linda's the president. I'll talk to Linda about it.
So right now, the ordinance is rolled back 15%. So when someone comes in for a modification, there's a local architect, right? She does a lot of work in your neighborhood.
She's great.
No, she's spot on for sure. But she's aware of that regulation, right? So she's coming in and she's asking for that 15, or let me not use her personally, but you can come in and ask for that 15% modification, which will get you right back to where you were, right back to where.
Yeah.
What I believe, Mr. Dono, correct me if I'm wrong, that your ARC has incorporated the setbacks of the ordinance. Is that accurate?
Yeah.
So that it would ultimately bring you to those setbacks with that modification. If you roll back to the old numbers, you can then get a 15% modification on top of that, which brings your buildings real close. Yep.
Yeah. Okay. I'm not sure if we were totally aware of that.
Sure, and I'm happy, like I said, to talk with anyone.
Yeah, I'll take it back to the board tomorrow. I appreciate it.
Yeah, that would be great.
Yeah, we don't want to be, we're tight. And if we have 2 houses, grabbing an extra foot, it gets even tighter.
Yeah.
Mm-hmm. Sure.
When I saw the request, I'm like, I'm not sure they understand what
Maybe that's
they're
some
asking for.
confusion.
Yeah.
Thank you.
Thank you.
And you can, Nick, you can email me tomorrow. And,
I will. I'll talk
Okay.
to Linda tomorrow morning.
Thank you for coming and
Thank you, guys.
waiting here for.
For the rest of where we've been. Are we finished with that topic?
You want to have more discussion? I have more discussion, but I don't know if other folks want to talk.
Go ahead, Rupert.
So I did this data analysis because I thought it was pretty interesting. And I have actually enough for everybody over there. And so I looked at so from previous. Somebody did a FOIA request to the building official back in May. In 5 years ending May, there were 5,229 applications for building permits. And of that number, 167 were reviewed by planning board and zoning board. So only 3.2% comes to us. The rest are handled by staff. So a pretty small percentage. And then I looked at each of these. I looked at the variance and special use permit applications, and a really high percentage are on substandard lots, and I pulled it up by R10, R20, excuse me, R40 and R80. And then you saw I pulled out Breakwater Village separately. And then Knowles Camp also is an unusual situation. There were 3 of those in the business and commercial. And even business and commercial, 59% were substandard lots. So, so this, to me, and it's hard to tell. So the substandard lot rule was adopted in December 2023, but really because of the application lag, really we probably have about a year, and I couldn't pull out the difference in what happened with substandard lot. You know, how many more variances, how many fewer variances came in. There's sort of anecdotally, I can say that it looks like fewer variances since the substandard lot came in, but it's not enough time to really have a trend. And then I looked at the address of the applicant and the activity requiring the variance or special use permit. So of those 100 and whatever it was, 167, 44 were demo rebuild, 28 were additions, 27s were deck and porches, 13 new houses, 13 garages, 9 pools, 5 walls or bulkheads, 3 sheds, and then 12 commercial. And then this was interesting. We had 17 before us for legalizing completed construction, 18 today, which was 11% of the things in front of us in the past 5 years were to legalize stuff that was built. And then what I did is I broke out, because I heard from the council sort of an assertion that, you know, the setback standards were needed because they're preventing residents from adding to the house so families could live here. And it looks like the vast majority of demo rebuild and the vast majority of additions are not Narragansett residents. And in Narragansett, only 28 of the 81 applications, which is 36%, are for expansion of living space. So this is 36% of the 3.6%. So it's a pretty small fraction of the applications. And then I already presented the data on the modifications. There were 64 applications, and this is modifications recorded in the records, in the town's land evidence records through October 31st. So 64 applications, 61 automatically approved. There were 3 objections which came through us. That was before they changed the standards for objections. So now that the standards for objections are only the abutters, so nobody else can object. It used to be they published in the newspaper and other people could object. And I think, were any of the objections that we had abutters? I think 1, right?
For the 15%
For
modification?
modifications, yeah. We had 3 that came through, and I think only 1 that was objected by.
You definitely
abutters.
had 1 that
Yeah.
was an actual abutter.
I think that's the only one now.
Mhm.
So the standards. So the reason I did this, so when we got the law changed, we had a very short time to change all the laws. You know, this came from North Kingstown. It was adopted in, I don't know, July, and we had to have all these things in place in January, and giving time for town council hearings and all that. I think we had to get into the council in sort of mid-October, so in a very short time to really redo the zoning ordinance, the subdivision ordinance. And when we looked at the impact of substandard lots in town, and we said, okay, 15% on this, how do you really know? How do we know what the impact's going to be? So we, in abundance of caution, sort of said, okay, let's set the standards back 15%, so that with the 15% modifications, it keeps basically the zoning standards that were in place, that have been in place since the 1970s. So that was the thinking. And the thinking was to look at it in a year and see what the impacts are. We haven't had a chance to look at it because we've had a lot of stuff thrown at us in a year, so we haven't really had a chance to look at it. So this was the best looking at it I could do. We still don't know. We don't have good data on the other 96% of building permits. We don't know whether they're for additions, whether they're for new houses, whether they're for fences. But this was the best I could do with looking at the information on the record that I could get to see where the impacts were and where the impacts weren't.
Rupert, where did this data come from?
It's the land evidence records. It's
How did you
reported.
access them?
It's online.
It's online?
Yeah. So I did a search, decisions, zoning decisions, January 1, 2020 through October 31st of this year. Yeah. And so it brings up everything. So then you have to go through, okay, what are modifications? What were staff done? And you filter through and you get the ones that went through planning and zoning. And that's what these are.
Yeah, my impression, if you need to pull a building permit for a lot of stuff. You know,
Yeah.
you install
Fences. Yeah.
Well, but even you want to install solar on your roof.
Yep.
You want to do some electrical work in the house or mechanical work.
Yep.
So there's a ton of stuff that doesn't apply essentially to the expansion of
Right.
the physical footprint of the house. Or whatever.
Right. Yeah.
Mr. Friday, can I just ask a quick question to Mr. Callahan's point?
Yeah.
Did you pull, so mechanical permits and plumbing permits are separate than a building permit, they're separate permits. Do you know with the APRA that was done previous, were they only building permits or were they inclusive of mechanical and plumbing,
Don't know.
electrical?
We should know that.
Okay.
I can answer that. The mechanical permits were not included in the information that we discussed to pull the information. It was strictly building permits that I showed you how to download the
Yeah.
information with it being a zoning.
But the previous APRA, I don't know if that included the mechanical or not.
It did not.
Oh, okay.
It did not.
Okay, good.
It was strictly, if you're referring to when I had previous conversations with Terry Fleming.
Okay.
And it was strictly building permits,
Okay.
not mechanical, because that was a discussion of differentiation.
Yeah. I just got that from other sources, so I don't know.
I've got a question about this.
Yeah.
Because I'm just adding it up.
Yep.
You have all the building permits being granted here that are applied for in your numbers, right?
No, so looking through the ones, the variant, I'm looking at variances, right?
No, I'm looking top line. You got 5,229 building applications.
Yeah.
167 were reviewed by us. All right, so either accepted or denied, yeah, and then
Yep.
5,062
Yep.
by staff.
And or by staff, yeah.
I asked this at the work session too.
Yeah.
I don't think those numbers are accurate, because I know people apply for building permits and they never go anywhere. So that was what I asked then, how many of them were there?
This information was supplied by Wayne's office in request to somebody
Gotcha.
who didn't.
All
Yeah, I
right.
don't-
So we don't know how many are just applied for and never.
Yeah.
So Mr. DeSimone, is the question the application or the permit? Because you're right, there are a lot of
Yeah.
people who apply and the permit never comes to fruition.
Yeah, that's what I'm concerned about,
Mhm.
because our regulations are, if you're not rich, if you don't have the wealth to pay lawyers and engineers and surveyors, you might apply for a building permit, become immediately discouraged, as I've heard from numerous people, and then give up, and that application goes nowhere. So they don't know they can get a modification, they don't have the money to do. What you're pointing out is great, but these are the people with the money to do this. And I worry that the extra, every time we add something to the code, you're discouraging someone from doing something with their property, what they'd like to do. And that, I've already heard from several families, They've passed on houses because they think it's not gonna happen. They're not, and I know things have changed, and I'm sure that you would guide them very well and tell them that they can get a variance if they need it, or they should apply, or whatever.
Sure.
But they certainly don't have the money to flush down the toilet if they think that's where it's going. And I've heard from a lot of people that that's where they think it's going.
So I can't speak to applications.
Yeah.
What I can speak to is the number of variances that were denied was very few.
Yeah, that's great. I mean,
And the ones that were denied, it seemed in many cases were things that were built illegally and then really illegally.
yeah, sure.
Is what it looked like walking through, reading through the
Can I ask,
reports.
you bring up a good point, is the application process so difficult that a lay person, is it the forms, the whole process is such an adventure that they've gotta get legal engineering,
certainly.
construction
There's-
advice right to begin with?
Yeah, I mean, you've read our zoning code. There's a lot of stuff going on in there. And if
No,
you
but
don't,
if you walked into the building inspector, I don't know. Maybe I should do it.
So,
Walk
Dr.
in the
O'Neill-
building inspector's office and
Sure.
and say, I want to, what forms, tell me, maybe it is,
Right.
maybe it's a mountain. Maybe we can do something about it.
that'd be nice.
So I can answer that for you, Dr. O'Neill. It is an online application. We used to have a paper copy application where you could come in and, staff would work, my department, our department, community development would work with you, help you to fill out the variance application, which you are actually still required. But a building permit application is all done online now. So anytime somebody wants to apply for a building permit, regardless of what they want to do, whether they're going to zoning or not, it's an online application. I've done it for my own town. It's not a Herculean effort, but it is, if you're not a computer savvy person.
But to Steve's point, I mean, you are required to get a survey. You are required to have, engineering stamp
You would be
designs.
required for that regardless.
Yeah, and it's not anything we're talking about that affects that.
Well,
Right, in the stormwater calculations, and that's
Sure.
all.
but what I'm saying is,
That's
when you look at
that's
our code
enumerated. Yeah.
right now,
Yep.
because of what this board did and the previous town council did, all of the setbacks became 15% more stringent. So somebody, a lay person, who wants to add an addition to their house, they look in the code and they see, oh, I gotta be X number of feet from the lot line. And they decide right then and there, that's not enough room, I'm not gonna go forward. Whereas what you guys said previously and what we said is the reason you did the 15% was so that when you get the 15%, you're back where we were.
Right.
I would prefer we go back to where we were, and Wayne should evaluate the modifications on a case-by-case basis, as he should, as he's described to do in law. I disagree that he can't say no. I think it's very obvious he can say no. There are criteria that he can say no for. I understand he hasn't, but that doesn't mean that he can't. And you're making it onerous on people, and you're scaring people away who we might want to keep in this town. Because they don't know they can come in and do all this stuff. And if you're looking at a $10,000, $15,000 bill to find out if you can do an addition on a house you don't own, you're not going to buy the house. And then we lose another family. And then we've got another investor in. Because I'll tell you right now, they've got the money. You're concerned about that. They've got it. They can do it. They got the lawyers, they got the engineers, they got everybody. So, I mean, I know we're not going to get this to a zoning code I'd like. I'd like a zoning code where we don't give any variances unless it's crazy extreme, and everybody can do what they want to do within safe bounds.
So,
But, that's a pie in the sky dream.
so are there any standards? Should there be any?
I think the standards were fine. I think that you did a knee-jerk reaction. You ratcheted it up by 15% on everybody.
No, because you actually have it reduced by all the substandard lots?
No, to any lot in town, that was gonna happen whether you did this or not. So you ratcheted it up by 15%. You ratcheted it up on non-substandard lots, you ratcheted it up on substandard lots, you ratcheted it up on commercial lots, on industrial lots. You ratcheted it up in every zone across the town. And I can't believe they're letting it stay at 30 feet, because I built a ranch at 32 feet tall. I understand, I left one of these meetings and I heard people behind me on this board talking about how they don't want a 35-foot tall house next to them. Well, that's what the code was. And you exploited this to shrink houses to 30 feet, and the board's gone along with it, and that the council's gone along with it, and that's fine. We're not here to change that. But I think there's a way that you could have a compromise on this. I think 15% is extreme. If you wanted to do, maybe we go back 10%, so the 5% waiver that doesn't require notice is automatic, and it gets you back to where the code used to be. I think that's a great compromise. But if you want to stick at 15%, you stole use from people in this town who don't have the money to fight. And I think that's reprehensible.
So,
The application for modification is, it's a one-page thing. It doesn't take a lawyer.
Yeah, but in order to apply, you have to hire engineers, surveyors, and lawyers.
You have to do that to apply for anything.
What I'm saying is, when you first look, you won't pay that money if you don't think you can build the thing. If the code was you gotta be 8 feet from the property line, and now it's you gotta be 12 feet, if you needed to be 8 feet, why would you hire an engineer and a surveyor? You don't know you can get an easy modification until you pay somebody to tell you that. And the developers know, and the investors know, but the layperson doesn't know. I hope they're all watching this and they figure it out. But I think what happened was a knee-jerk reaction and an overreaction, personally.
So I have also gone through each of the pieces to say, okay, does this matter? Should we have left it the same? Which we would have done if we had time when we originally did this. And we would have done, you know, the plan was to do it a year after looking at implementation. And I can walk through what I suggest where it makes sense to change it back to the original numbers.
I love it.
But a 5% modification is the same process as a 15% modification.
No, it's not. There's no notice.
The notice is to 3 neighbors.
The notice is to everyone that goes in the paper. Jill already said that. The notice goes to everyone.
can I,
Tom, you
It's
wanna
not
speak?
by right, and they get notice. I'm sorry.
Tom, no, don't be sorry.
no,
No, it's
no,
good
no,
discussion.
It's good
Tom?
discussion, and I want to come back to it, but I want to do a couple things before we get there. I got a couple questions for staff and for council. For staff, before these modifications, before the dimensional table was changed in 2023, 24, how long had that table of dimensions been in place with those setbacks as they?
I looked for the workshop. and
78,
Yeah, it was at least.
60 something, 68.
And the reason I ask that is, to your point, Steve, there are several generations of people who have worked with those setbacks in place, who have relied on the fact that you're coming at it from the vantage point of individual property owner, have the right to do what they want with their property, but there are also that group of, there's a group of, everyone else is looking at, not everyone else, don't mean like that. It's another point of view that said, when I bought, this was the framework. And now what I've got is an incursion I have a potential incursion into the quiet enjoyment of my own property because of the expansion that's going on beside me. So there's 2 points of view on this piece that you talked about. Something that's been in place for 30 or 40 years, changes like that should not be done cavalierly. And I think once the thing, from my vantage point, and I wasn't on the board at the time, but that set off basically the fire bells in terms of we've got to do something to do it. Leave that, but I think the reason I raise that is I want to say, look, there's at least 2 points of view on this. One is, I had an opportunity cost associated with the changes that right? There's an opportunity cost associated with the changes that were made as a result of that I cannot execute on right now. The flip side is if you're looking at it from the other lens, I have an unanticipated risk that I never thought was going to happen to my property. That is going to impede my ability to quiet enjoyment of that property. So, thank you for that. For you, Bob, there was a discussion that took place at the referral meeting at the council last week, or 2 weeks ago, where Mr. Menzies asked you about the interplay between the changes in the dimensional tables and FAR. And you said, yeah, there are, as I recollected, yeah, there are some factual circumstances that can or may create wrinkles that are based on facts and circumstances. Can you talk briefly about that tonight? And if not, maybe you can come back Monday and kind of talk to us about it.
I'll have to answer your question, Tom, you're asking me, can I, in an example, give you an example of when that wrinkling factor would happen. And I'll give it some thought, but what I'm concerned by saying that is I'm creating, this is a new law, so I'm broadcasting to the population here a hypothetical that they might say, oh, that's okay, we can do that now. And I'll cause more problems with the implementation of the intent of this statute by both the General Assembly as well as by the Town Council. But I haven't given it any thought. So I will, and I will do my best to come up with something that I don't think is violative of those two concerns I have.
Because clearly there's at least an opinion, there's at least one opinion, maybe more, on the council at this point in time, that no one want, not, that they don't want to monkey with FAR. And the question is, if you monkey with the dimensional, what's the interplay between the FAR and the dimensional? And are the simple changes that are reflected in terms of rolling it back enough to solve that problem, whatever that problem or opportunity might be?
Although I'll use my sense of humor for a minute.
Okay.
You become a lawyer because you stink at math, other than dividing any number by a third.
I've told a lot of people in the last week that I'm much better, although not good, at rhetoric than I am at arithmetic.
Oh.
So here's, the council, the council's asked for us to think about, Steve had suggested kind of a minute ago in terms of, well, one thing we might want to consider is modifying the number in terms of the setback. Here's a thought I want you to think about it. Is there a way to legally provide additional relief to a class of people who are deemed to be that basically are eligible for the homestead exemption here in town? That would focus on long-term residents and provide an incentive for that kind of behavior. So I don't know, you don't have to answer it now, but I would like you to think, and maybe you can answer it now. If you can, great. If you can't.
No, that's a unique question. You're addressing the problem in ways that it's been addressed in the past. It was always thought that residency would continue if there was some type of a grandfathering of certain rights and the capping of taxes. I'm a North Kingstown resident, and for years that was the case because we came to believe after the Navy moved out and those that stayed died off because it was a single generation that kept those houses with no kids, by the way, in the schools, although that's not necessarily the problem here. And so they decided to give people that tax break, and I'm not sure that it did anything other than give a tax break and didn't achieve the result that you're looking for, which is to keep the fellow who bought the house 40 years ago, raised a family, and now two of them are left, and you want them to stay. And it did not least the fact that other than maybe taking an ambulance to the hospital once in a while, that they're a lot less expensive on the municipality.
Yeah, I guess I'm looking at it from this vantage point. If you want permanent residents, if what you're hearing from permanent residents as you're out on the campaign trail is I can't build, I want to add an addition to my house, I can't get that addition to my house because X, right. Y, and I can't get through either can't get through the process because it's too complicated, too expensive, or more importantly, I can't physically get done what I want to get done because I can't get the amount of area on the parcel that I own.
Right.
If you basically if you could focus that benefit on people who are actually permanent residents, as identified as the home, basically having qualified for the homestead exemption, then I think it at least tries to get to that particular feedback that you're getting out in the community. It may or may not work, but for the purposes of being responsive to the council and saying, this is what I'm hearing, and what about doing something like this, I'd like to know the answer to that. The other thing, to the point that both Steve and Rupert were talking about a minute ago, if you look at the FAR chart, in my judgment, what's good about the FAR chart is it's indifferent to zone. It basically says lot size this is what the FAR is, and it's in 1,000 square foot increments through 20,000 square feet, right? And if you look then at Breakwater Village's matrix in terms of how basically the world works there in terms of side yard, back, front, blah, blah, the FAR is in there as a part of that. And so I'm wondering if, again, in an effort to simplify, somebody saying, okay, how do I navigate this situation, is if you could, within the zones, do basically the equivalent of a Breakwater Village matrix, and then instead of being in 1,000-foot increments in the larger zones, maybe they're in 2,000-foot increments, or they're in 4,000-foot increments. And then this notion of what applies and what doesn't tends to go somewhat away. And lastly, if you look at the language in the stuff that we're doing, okay, and just in this thing that we're doing, we have the following terms and how they apply. Okay, we have maximum site coverage, we have maximum building coverage, we have maximum lot coverage, we have building coverage, we have net lot coverage, we have net lot area. If you're a layperson out there trying to understand the world according to Gore, I need to get one of you two guys to help me, because you won't find some of those terms in the defined terms in the ordinance. They're basically carried in a section someplace. It seems to me that there must be a way, either through recodification or some other way, shape, or form. And I know recodification, I'm told, is not cheap. But if part of the objective is to make things simpler for people to get done what they want to get done, an investment in doing something that simplifies the code as opposed to simply adding to it or something like that would be, I think, extremely helpful for what it's worth.
Love it. Love to work with you on that, anytime.
But moving right along.
Tom, if I can, you talked about my quote from a meeting a couple of weeks ago, and I'm talking about the wrinkles of the facts. You just hit on the nail, the top of the nail, right on the head of it. That you're talking about a failure to define within a statute which creates an ambiguity, which brings you to court, which has a judge interpret what it means, and then there are experts that testify on both sides, and it goes to the Supreme Court. And that's how you make under this method, that's how you make the traditional, well, this is what it means because in Jones versus, Craven, they said the following. And an attempt to do that by recognizing this effort on the part of the General Assembly, and I can speak of this because few times do you have the historical background of legislation. Well, I'm here, and I can tell you I was there, sitting at the table and participating in this thought process.
You were the sausage man.
Yeah. Hot dogs too, that's what they say about it. Hot dogs and legislation, you never eat one if you knew what it was made of, or how they made it. But it was what I believe to be a a noble obligation on the part of this state to allow people to be able to live in places, and in this community, for people to be able to come and create some diversity, especially for economic opportunities for your employees, teachers, firefighters, police officers, to be able to live here, because it's an expensive town. It wasn't when I was at URI. I lived a couple of years down at Bonnet Shores, and it was very, I rented a place down there for $200 a month, which I thought was a lot of money because I didn't have a lot of money. But so now they're trying to create some opportunity, literally out of whole cloth, create this opportunity. So your thoughts are, is there another way to create it that gives more definitive parameters, so that Stephen's concerns about, somebody looks at the book and says, there's no way I can do this, I can't afford the lawyers, the engineers, and the surveyors to be able to do this. I think that's a noble way to follow up on the original intent that I remember we were discussing on the House floor. So.
Can I raise one more point? Sure. Again, I'm somewhat better at rhetoric than arithmetic. But I think if you run the numbers on some of these things, and you look at, for example, let's take an R80 or an take an 8,000 or 9,000 or 10,000 square foot lot, substandard in an R80 zone, you might end up with the ability to build, I got it right, 1,300, 700?
Are you talking about FAR, or are you talking about lot coverage?
Lot coverage.
I think we calculated about 1,750 or 1,850.
1,750,
Yeah,
right.
it was under 2,000.
And if you had the same 80,000 square foot lot in an R10 zone, I could construct what?
Oh, I thought that's what you're talking about. Are you talking
Right.
about, if you're talking about like a 9,000 square foot lot on an R80, you can get to about 1,800, I believe.
Right.
The same 9,000 square foot lot on an R10, you can get to about 24.
How does that make sense?
I agree with that.
I mean,
Might be 2,200.
Yeah, how does, I mean, when you think about it, if you sat down and kind of run the numbers on this, if you had the time, and you did a serious effort, and say, does it really make sense? Is that something like that? My house is in a substandard lot in either location. In the R80 zone, I can only get this, and on an R10 zone, I can get, the result seems to be counter to what the council is trying to achieve. And so in order to figure that out, we will need more time than we've got right now to figure it out. I'll just say that right now. But it is something in communicating with the council and say, look guys, this doesn't make a lot of sense. And we really ought to be taking a harder look at how to do this before it's over.
But it takes some time to do it.
And yeah, you gotta take time.
Can't do it under
Right, exactly.
30 days, 60 day time clock.
Correct.
Okay, any further conversation on these points? Nothing else?
You were better for 6 torturous meetings. I don't know if you want to jump in here.
No, I
They were
just,
wonderful on tape.
I'd probably pull 150 to 200 building permits a year. And it's, once you know the system, it isn't bad. But for people that aren't, I'm going to say, computer ready, setting up to go into the portal the first time is a challenge. Knowing what documents to submit, but I don't think that that's just a Narragansett issue, that's a statewide issue. When we went to the statewide portal system, a lot of the interaction left the individuals. One comment I want to thank you, but there's a tremendous amount of information here. And when I look at the amount of permit applications approved by staff, I wonder how many were actually applied for, because when I look at the amount that were ultimately, the modifications approved, I know that in almost every town, staffs do a fabulous job culling applications that aren't going to make it. And they tell people, this doesn't have a chance. Why are you wasting your money? You're just not going to put an 8,000 square foot house on a 5,000 square foot lot. And people walk away, and a lot of them do quit, and rightly so. So I think the numbers can be, 5,062 approved by staff. That could be someone just replacing windows, it could be someone replacing a door, it's any modification over $500. So we don't know that, but to kind of jump ship a little bit, when I go to the November 16th, 2023 memo and the recommendations, one thing that does trouble me is the very last line of the whole.
What page are you on?
There's a memo to Eva as the council president from Chairman Fleming dated November 16th, 2023 in our packet. And it's right at the very end before the vote. This is in tab E, about 8 pages in from the beginning.
I got it, Jim, go ahead. Yeah.
And it says, for the reasons cited above, the planning board concludes these proposed changes clearly respond to the state's mandate with respect to dimensional discretionary components proposed. That's the part that I have a problem with, is that there's a hierarchy of law in the state, and we don't always like the laws that we're given, but to propose something simply to be contrary without any findings or any reason why. We heard the discussion about the setbacks, and the two firemen spoke about 5 feet on 2-story buildings and 8 feet on 3-story buildings. To me, that's a finding that makes sense. It's a public safety issue. To just roll everything back 15% arbitrarily across the board doesn't necessarily make sense. I understand that the previous ordinances stood, and I think it's back to, 1967, 68 was the first building code in Narragansett.
Yeah.
And I think I still have my old yellow book. It's about this thick, and that was our entire building code.
I have one too.
We'll have to give them both of the towers. A lot of the numbers haven't changed, but I think that we need to find a reason to modify them, not just to go 15% for everything in the entire town. There should be individual findings, individual reasons, and justifications.
So when I started going through them to talk about ones that I thought make sense to roll back, I think so when we did this is deja vu all over again, but we did this in March or April when stuff came before us. I think we got legal advice from both councils that really, we couldn't redline the red line, we had to vote it up or down, right? That's the advice we got then.
I think to Tom's point, it will take a lot of time to go through every single one, and there's a lot of things in there that are a lot more confusing than they were in 1968. And maybe simplification is part of the answer.
But I went through their red line so that we could provide comments back, things that I think make sense to roll back, where it doesn't impact the character of neighborhoods.
And I think to your point, Jim, the real flashpoint on the dimensional regs has been residential stuff and substandard lots of records. So it's a small, it's not to say that the rest of the stuff doesn't need attention in terms of kind of the logic associated with it and the rationale, but it's that stuff on substandard lots of records and like I said, doing the math, figuring it out, so on and so forth. It's going to take some time to get to the point where you can justify individually, line by line, what you've done. If that's what you're suggesting you're going to do.
It's going to be very time consuming.
Exactly.
It's going to give you a more proper ordinance.
Right. But in the meantime, whether we roll it back or we don't, or we roll it back halfway or some way, we're still going to suffer that vulnerability of not having a strong set of findings, other than the fact that those are what we had before, but this is how we changed it.
I just wonder if someone were to challenge them and they go to court without the proper findings. I think there was a case in the last week that came back I don't know if you're familiar with it,
Yes.
about
I
lack,
am.
about lack of findings.
Mhm.
And it
I
wasn't,
saw that.
wasn't a South County issue, but I think that the findings are key to the ordinance having a good legal footing to be upheld. And the last one wanted someone to take one of our decisions and get it overturned because something wasn't properly supported when we got to it.
Steve wanted to speak up.
I was just gonna ask Rupert what those parts are that you think,
So I sort of went through the ordinance section by section, the
Alright.
changes. So on the, so the first part two, the high water table stuff, in the high water table in town sort of impacts flooding, right? So I think that you could roll back the standards in business and industrial, and it wouldn't really make a difference. I think for residential, you see it making a difference. On the Breakwater Village, I think that probably makes sense to roll back the accessory structure height. I think the others in Breakwater Village, I mean, that's where we see things built to the line. And I think if Breakwater Village wants them rolled back, and they make that decision, I think, you know, it's their neighborhood.
yeah, I totally agree. That's why I was with you guys on that the
But-
first time around.
But yeah, I just, so they understand the consequences of what they're asking for, I think.
Yeah.
Port of Galilee, same thing, I think you can roll back the Port of Galilee. Where the residential is in Galilee is separate from the industrial and all the others, so I think the impact of these standards, changing them, wouldn't really impact things. Special planning districts, planned residential, again, the same thing. I think if you're doing new planned residential, you're developing the standards as part of that. The dimensional table, I would argue for residential, keeping it the same except for the height of the accessory structures. I think the accessory structures, rolling them back to the original. I think the 15% on top of the 18 for the accessory structures isn't going to cause a problem as far as the character of neighborhoods. The business and industrial, I think we could go back to the originals and the same thing. I think the same reason. I think 15% in those areas isn't going to change the character of the community. Although when I did look at the data, there's an awful lot of substandard lots in business and commercial. So I think it could have impacts. I mean, it's on all these, like making generalizations. I mean, you don't know. It comes down to looking at the specifics of each lot, what the impact is, right? It's different depending on the specifics of each lot. But my take on the industrial and business is that 15% doesn't matter, but the text at the bottom of it, where you have minimum setbacks from boundaries of residential zones and setbacks to commercial from industrial zones, I think that minimum should be kept. I think that's important. The floor area ratio, I think, should be kept. I think it provides a backstop. I think we've done an awful lot of changes to the floor area ratio already. When the first year they modified it, took out garages, and then taking out cellars and basements. I think probably it's not going to have a huge impact on development at this point. But I think keeping those standards as we change them in December 2023 is probably a good thing to do. On the floor area ratio, one of the standards that was changed was, so floor area ratio only applies on lots of 20,000 square feet. We rolled that back to 23,000, so that if you get a modification, it's 20,000. If you left it at 20,000, you get a modification, then it ends up that FAR only kicks in at 17,000. So that's why I think that's important.
Mr. Freddy, I'm sorry, can you just explain that one more time under the?
Yeah, so, the, it's on part 9 on this stuff. Is, so, any lot used for residential purposes less than it was 20,000 square feet, we changed to 23,000 square feet, which is at 15%, shall comply with the hardscape requirements. And it follows with softscape, and I think it follows above with floor area ratio applicability, part 9, number 2. If you change them to 20,000 and you get a 15% modification, then it only applies to lots of 17,000. So it eliminates the impact of floor area ratio on any lots greater than 17,000 square feet.
So 2 things.
Yep.
One, the table doesn't actually go to 23,000, so we'd have to augment the table. You'd want to talk about that. But 2,
okay.
Well,
no,
but just
yeah, okay.
there's a case law that just came out, and Mr. Grundy, maybe this is the one you're referring to. You're referring to the one on Wickeden Street, where the applicant applied for a modification to a lot area to get a to get relief from parking.
It was subdivided. He was trying to subdivide.
Well, first he was trying to subdivide, that didn't work. But then he was trying to get the modification of the lot. It was a 10,108 square foot lot, and he applied for the modification saying that the lot was just over 5%, and therefore he didn't need to comply with the 75 parking spaces he needed on a 10,000 square foot lot. So I don't know, Bob, if you've seen that.
I did.
Okay, I don't know if that would apply. I don't know if you can get the variance from the area.
Okay.
I don't, because that's not where you're seeking the relief. The variance would come from the hardscape, but I don't know if you can get the variance from the area. I just throw it out there because I don't know the answer.
Well, if that's the case, I mean, when this was written, like I said, it was all new, and we're like, it says 15% of any dimensional standard, so it's a dimensional standard, so that's why we changed them.
Right, but so I say, okay, well, 10,000 square feet, a 10,000 square foot lot area in an R10 is a dimensional standard, right? So if I have in that situation, right? Can I apply that? I don't meet the standard. Can I get the variance to get me something else? Like, you're not seeking relief from that lot if you were applying. And I don't think you can do this, but a subdivision, you wanted to subdivide lots and you needed 10,000 square feet, but now you want to come in, you've got 9,900. Can you apply the modification to get the variance of the lot area relief that you need to get an R10? That to me seems connected. There's a nexus.
Yeah.
This, I don't know if that requirement of the lot area isn't. That's the information that gets you to the dimensional regulation where you would be seeking the variance from. Again, we have legal here, so I don't know. And this I literally just saw it. Say Tuesday. I think I just saw it like late last week. So
if that's the case, then we certainly don't need it to be 23. So on the planning board, the 2 years I've been here, I know we've seen projects that came in that were like 20,000 and 10 feet or something like that. When I was looking at this project, I'm like, this should come under FAR, but it didn't come under FAR because it was 20,000 and 10 feet. And so. Right,
which goes to the table issue. So I pose it to Bob because I don't, and maybe I'm sure you don't want to wait till Monday because I just threw the question out there, but I don't know if that would even apply. I don't know if you can do that.
Okay.
Based on that.
That
case law, which I will send to you if you guys are interested.
That case, if that's true, then changing those back makes sense, right?
Because I think that the state law, and this was addressed here, the state law only gives a 15% administrative modification for all dimensions of which a variance can be sought.
Right.
So you couldn't
Okay,
seek a
okay.
variance of the initial
Okay.
lot size. It would only be for
Thank you, Jim.
things like setback.
Yes.
So then that makes sense, yeah. So, and change those.
So, I'm sorry, so then, you're suggesting to roll that back to 20?
Yeah. Because we changed it based on a misunderstanding of what the implications were. Let's see where we are. So accessory structures on, it's part 10. I think changing those heights back makes sense. And I think the last paragraph of that, which reads, an accessory, it says on my copy, it's page 8, I don't know, it's on part 10. An accessory building or structure over 15,000 square feet in ground floor area, and it says, or greater than feet in height shall constitute a special use permit. I think it should strike the language there, greater than feet, because it's already covered in the above language, and you shouldn't need a special use permit for changing the height of a accessory structure from. Does that make sense, Joe?
It does to
Okay.
me, yes, because it's already covered, but if we're on part 10, and I'm just trying to make sure I have your comments. For the accessory structures, it would be to roll back to 13 feet, 13 feet, 18 feet, and 18 feet?
Correct. Yeah.
Okay, thank you.
On part 11, this is which you talked about, this is industrial maximum lot coverage and stuff. I think it makes sense to revise those back to the standards. On part 12, it's again development standards for nursing, convalescent homes, group homes, and orphanages. I think it makes sense to roll those back to the original numbers. I think that's not going to happen on a substandard lot. I just think when they come in, they're going to be reviewed pretty carefully. The same for section 13, standards for motels and tourist courts. The standard that we changed there is parking from boundary line. And I think rolling that back doesn't impact the character of neighborhoods. On part 14, this is the development standards for residential cluster developments. I think this is important to retain. Those changes. And then multifamily dwellings, part 15, again, I think you can revert those back to the original numbers. So that is my walkthrough, thinking about them piece by piece and the impact they'll have on neighborhoods and the character of the community.
I really appreciate it. Because I didn't hear that the first time we did these meetings, because like you said, it was a red line thing. I know, but we spent a lot of time. I would have liked to have sent something a little more constructive to the council so they could go in and this might have come back to us a little bit more changed rather than just they acquiesced on the height.
I mean, we had a workshop with them. And
No, I know.
They didn't change anything, so.
Well, they did. They took the height out.
Well,
That's a huge concession in my opinion. I mean, that's big.
Mr. Friday.
It's tall.
It's tall. Hey, look at that.
yeah.
Part 14, number 6, is your suggestion to roll back or keep the landscaping and buffer?
I have these written out so I can give them to
Okay.
you.
Okay, everybody else might have picked up on it, I just didn't. Okay.
Part, which one are we doing?
14, number 6. FAR 14, 17.16. It's a landscaping and buffer area.
59 versus 50.
Yeah, I think that's where I would retain the standards that were developed in
That's
December.
what you said.
Got it.
Residential cluster roads to stay the same.
And I think this is important because it's retain the character in the neighborhoods that have been developed as cluster developments.
Thank you. Okay.
And in existing lots and cluster developments are likely to have substandard lots, so I think that's where the impact would be big.
Wouldn't those be, aren't those not substandard lots because they were developed as clusters?
They're not, they would, well, they shouldn't be.
Yeah, I'm just,
But
They
they're-
shouldn't
for
be,
my own edification,
right, no,
I'm-
they shouldn't be, so if
But
it's
they're
done
recorded.
as a cluster, they would have had those, the setbacks that, that we were proposing to keep. I would defer to legal to see if there was a question, because, you know, typically that's an R80 zone, you're doing the cluster so you can protect the open space.
yeah.
But you're recording lots, right?
Yeah.
And then the lots are smaller than.
Yes, they are, but they're done under that cluster regulation. So are they really substandard because they were allowed to be smaller in order to preserve the open space? So it's a question if they're really substandard, because you
Yeah.
could have done, maybe you could have done, environmental aside, you could have done a conventional subdivision. We've got 2 conventional subdivisions, you know, going right now. As opposed to clusters.
Yeah.
I would say, Rupert, that cluster zoning was the birth mother of these types of concessions and bonuses that have come in order to encourage affordable housing to be built in a place where the land itself is very expensive. And the bonus has already been given in a cluster. It's already said you can build this amount of house, you can have that density, and you get more houses in a smaller area, but you have to have, you know, space which will be open and promote the environmental goals that led to
Right.
cluster.
Right, I understand that. So the development's done 10 years from now.
Yep.
Somebody buys a new house there and says, I want to tear down this house and build a new one. Do they get the
They would fall
rules?
under the cluster subdivision
They would.
regulations.
Okay.
Yep,
Okay.
that carries, that cluster restriction is with your deed. There's no screwing around with your deed when it comes to the law.
Okay.
I'm serious, you can't. It'd be-
So are we
it'd be
continuing
taking
this
property.
conversation on the 22nd?
Doc, I didn't know if we could just there's only one little bite left, and it sounds like everyone is in consensus again. Mr. Grundy pointed out that he, and I don't want to put words in your mouth, but you did reference the side yard setback, and how there was there was a nexus for the minimum side yard setback. But I know the 4 of you were already in unanimous consensus, so I don't know if you want to touch on that, or we can move it. It's the other thing that I am going to ask is, I can see we have differing opinions on the board, which is the requirement that's going to fall onto you on Monday is that you're going to need to find these changes, either what you're suggesting or outright, in this case of the side yard setback, is either compliant with the comprehensive plan. You're going to reaffirm the keeping of of not making the ordinance change, or you're going to need to, if you're going to do something back. So for instance, if you take Mr. Friday's rolling back, we're going to want to address that, and how, and I think we can address that very simply, like when you did this a year ago, or when the board did this a year ago. One of the suggestions was, there were 2 actually that the planning board chairman said to council. One of them was, we'd like to come back in a year. So we, that didn't happen because it came back to us in a year. And then he talked about adding additional staff, actually. So with that, if we're gonna pull that, if we're gonna suggest some changes to it, it's just making sure that that you're identifying the locations in the comprehensive plan, and I can help you with that. I can try to help you with that, but and/or reaffirming that your previous findings about the comprehensive plan are still in play, and the same thing with the purposes of zoning, because those are your two charges. So I just want you to be aware of that ultimately is the conversation that we're gonna need to make. That's the conversation. That's the report.
So, what would be helpful to me, is if I understand this correctly, is to see the write-up with the modification, with the proposed changes in it that we've gone through tonight. And get the questions answered that have been asked in terms of council and others, so that may or may not shape further the discussion and the work product on Monday night. And then to your point, are you proposing, if we go forward with the changes that the matrix changes that Rupert suggested this evening, are you also suggesting that you would draft the rationale vis-a-vis the comprehensive plan? The findings that, proposed findings that, as we would normally do, adopt as our own or not, and then make additional findings to go along with it.
I will give you a working draft.
That's one.
Yes, I will.
That works for me. That works for me.
Yeah, so if I understand it, we need to vote this up or down. Is the red line, right?
I think you better go through Monday first.
Yeah.
See what we got.
So that was a question I had to Bob a minute ago as a sidebar, which is the council has asked you, and I put it in here. I believe the council has asked you to do a couple of things, and of course I'm not going to find it right now when I bring it up. But one of them was if you're not going to give them what was the word they used? Ryan used a very specific word. Hold on. I'll look for it. Ryan used. Do I have that? Where's the? I'm sorry. I have too many papers in front of me, like I mentioned. Do you have the report for Dr. O'Neill? Right here. Okay. So the council asked that should the planning board be unable to recommend approval of the proposed changes, that they consider offering a middle ground, and that, as someone already mentioned here, that the existing FAR restrictions may be supported as currently in the ordinance, subject to legal interpretation, that they do not affect other things. So I don't, Bob, can the board make a, instead of, the advisement from legal was previously, and I think it would probably be the same, as we can't give them back a red line. But can they, in their, and this has been done before, in their recommendation, put their considerations in text format, so that way they're spelling it out. You're spelling out what you want, if the board agrees, what you want to roll back, what you want to keep, what you you can, in the body, and I'll do this for you, but in the body, lay out some draft language, either standing by what you've done twice or modifying, but have there be the considerations at the end. So that way, this board is being responsive to the council and not just going, pulling a Caesar maneuver.
Or another option would be, maybe it's the same thing, it sounds to me that if we are not prepared to endorse in its entirety the recommended changes that the council has forwarded to us, that we simply say no. However, but, and then in a report, however, but, here are a set of recommendations. We're making an agreement.
Yes. I think you can do that.
Right.
And I think if you're going to do that, you should be making that connection as to why those recommendations are do comport.
Right, because you can't, I mean, if step A is you're gonna say yes or no, and that's the only thing you can do based on what we've heard. We'll have to say, at least based on what I see right now, I'll probably say no, wherever other people end up, they'll end up. However, but, based on the conversation tonight, some additional thoughts, here are the things that, if we weren't forced to say yes or no, we would have said otherwise. Right?
I think you can do that.
Right.
And, one thing I heard tonight was Breakwater Village. It's a different animal. It might not be an up or down candidate because of what we've heard and what we may receive between now and Monday from the board itself as to their view of the specific impact of not rolling back or whatever.
Would it be
I think we-
possible, I'm sorry, Bob.
Go ahead. I think the council would be receptive to that, in my opinion.
Okay. Would it be possible between now and Monday to get something from the fire marshal if they had a specific opinion referencing an FPA, either 101 or 100?
I have that.
You have that?
I already have that.
Okay, because I think that that's an important part of finding, to establish minimum access ways, minimum setbacks, regardless of statutory relief that the state wants to give, that gives us a good legal finding to have minimums after relief.
So the state building code, so the fire code for 1 and 2 family, I'm paraphrasing now, and I believe I've sent this to Bob already, and waiting to have a follow-up conversation on that, is, and if they're listening, they'll correct me tomorrow, I'm sure, that residential dwellings, 1 and 2 bedroom, the only thing that can be regulated are,
One and two story or 1 and 2 bedroom?
I'm sorry, 1 and 2 units. 1 and 2 units, my bad. Thank you. The only thing that can be regulated are the smoke detectors. So if something is too close to a lot line, it has to be fire rated. But that's it. And the fire marshal gave me all of the language about about how something more stringent, yada, can't be done in the fire code. I put it in the report that the zoning enabling legislation enables you to set your own setbacks, and it does so very specifically for the health. One of the reasons is the health, safety, and general welfare. So independent of that, of the fire code and the ladders and the trigonometry table that we did 10 years ago that showed you that you can't actually get a ladder without a forced trespass. That it's the general health, safety, and welfare, which does, again, you have an attorney here, fall under your purview.
So if we had a recommendation of their professional opinion as the town's fire safety official, at least that.
I don't think he would do that, no. I have asked on multiple occasions, and he's going to, and what he's done is he's fallen back on his regulation, and rightfully so. He's fallen back on his regulation. The town does have one ladder truck. I also know the ladder truck can't fit everywhere, so.
We had during, in March, we had testimony from somebody that was the assistant fire chief in Providence and teaches fire.
And a retired firefighter.
And we had a retired Narragansett firefighter supporting the 5 foot.
I know we also have certain mechanical code that limits exhaust to distance to property line as well. So it hampers your ability to put high efficiency heating systems, kitchen exhaust, anything like that. So you have certain minimum distances.
Right, okay, yeah, no, that's must be a building code thing.
Do you know what the distance is?
Depending on the appliance, it could be either 5 feet or 10 feet to property line, or to obstruction.
So
I consider property line to be a visible obstruction.
So 5 feet makes sense there too.
It does.
I was thinking about it, my neighbor has a shed literally on my property line, They can't paint their shed without trampling on my garden, so.
Ready to move along?
Do we have a path? We have a path?
I'm gonna give you something on Monday.
Okay, sounds good.
You might not get it till Monday. But I'll have something.
Reconvene Monday at 6 PM.
Monday at 6.
All right, moving right along. I think the minutes are up next here. August 19th is the only one I think we have from the
Correct.
right? The other two were deferred.
I move to continue the other two sets of minutes.
Well, you don't want to continue the minutes, you want to approve or disapprove August 19th.
Yeah, I can't do that when I'm not here for that one.
Well, you're not here for a while.
So, Mr. Chairman, I'll move the approval of the minutes for August 19th,
August
2025,
Okay.
if there's a second.
Can we do that? How many of us
There's
were
the
here?
3 of us. I was here on the 19th.
You were here? Second.
I wasn't here in June. I was,
Okay, so we can do it.
It's August.
The three
We
of
can
us.
do, yeah, we can do this.
yeah, all right, I'll second it.
Second it, okay, all in favor of the three of us?
Aye.
Got that aye?
Abstain.
302.
302.
Okay, moving right along then, planning board liaison updates.
I'm sorry, Dr. O'Neill,
What?
motion to continue October 21st and November 18th.
Yeah, I thought I said, we're deferring them or
So moved.
continuing? So moved, there we go, move.
I'll second it.
Okay,
All right.
thank
All in
you.
favor?
Aye.
Aye. Okay. So moving along here, planning board liaison updates here. Appointment to the coastal access improvement committee.
Yeah, so I attended the first meeting and it's an interesting group and I don't really have much to report back.
Okay. And Steve, anything from Land Conservancy Trust?
We're working on the Sunset Farm plan, and I'm sorry, Jill, I meant to get you some notes this month. It's been a tough month.
That's okay.
I promise I'll get something in writing at some point.
No worries.
I don't think we're gonna come to any decisions on Thursday.
It's not even on the agenda.
Okay, even better. I haven't even gotten that far. I was consumed with this since I got that email.
It's
so.
not even on the agenda. We've got other angles
Great,
we're working out.
great. We're working on stuff, guys. We're working on stuff. We're working on some other cool stuff, but you know,
Keep working on it.
you know what I'm talking about.
I
Nobody else does.
Moving right along, legislative update, zoning ordinance, subdivision regulations.
So, Mr. Chairman, I would say on the zoning ordinance and the subdivision regulations, of which I am both a member of the subdivision regulations. Former Chairman Mark Brady was my compadre on zoning, so we have a one-person
I'm gonna ask to fill in on that.
committee on that. So I don't know that that's.
Great.
So now we've got,
I'm gonna ask to fill in.
okay, great. So, I guess these two have been hanging fire now for at least 6 or 7 months, as I can figure. And I'm hoping.
Not that long, Mr. Callahan.
Well, it just feels that way.
It does.
How long?
Well,
Since June.
by the time the state, maybe since July. All right, 6 months.
Okay, all right. So it's not 7, 6.
6.
All right, so what do we need to bring this to resolution? And,
Time.
no, I think there's a series of responses to questions that need to be answered, that we need to have done. And what might they be? And how can we get it done in order to move these things along? Because we've heard in one public forum lately, I don't know if it was town council or somewhere else, folks say you can't read this, they can't read the ordinance book, although you challenged them on it. You can't read the ordinance book and find the ordinances right now because that needs to be changed. And we've got the changes that happened, and we've got the council pushing to make sure everything's updated. So I'm curious, what might we need from either legal or anywhere else in order to get this stuff done?
You want to take the order?
Sure.
For zoning, right now I'm in the final stages of creating another draft for now you and Rupert and our legal team to review for the items that have been determined to be discretionary versus requiring action. And I have that, and it's essentially, it's in its final forms. I was reviewing it today, so I hope to send you guys the email later this week or early next week. And we can have a follow-up discussion as an in-person meeting to hopefully implement those.
Okay, so you have everything you need from everybody in legal?
I believe so,
You do?
at this time. Yep.
We just needed some clarification on the NCDM.
I think
We did, but I think internally, making sure that it's not, that we have something that we can hang our hat on. You know?
Okay.
And then if the committee wants to, that's it. I
So
just
that-
wanna have something we can hang our hat on.
So that sounds like you might have something for the next meeting, in terms of a report, at least. We don't have to necessarily act on it, but we have a draft ready
For zoning,
for zoning.
potentially.
January 21st. Yes, we'll have something.
We'll have
for you.
something.
Okay, good.
We might not have a report to go along with the draft, but we'll have a draft.
Yeah.
Okay.
I already have a draft. Actually, you saw it. I mean, it included things that weren't necessarily required to be included. So that I can modify that to include things that require action.
And how about on the subdivision side?
So we just still have some hanging chads with legal questions. I'm a little bit on the spot to be able to pull them together. There are some questions that the committee had regarding why certain things were changed, like why did the state law remove two of the standards of review for subdivisions. It's a format, it's also a formatting issue. I'm not as far along as Ryan. And we're going back, and by the way, we're going back from all the remnants that didn't get fixed in 2023 to the 2024 and 2025 changes. So I think yeah.
Do you have everything you need? From-
I probably have 90% of what I need. Yeah, except the time. And I haven't figured out how to make another 10 hours in a day yet.
or another
When
job?
someone else figures that out, let me know.
Me too.
It's one of those Harry Potter things.
Something.
Turns that thing.
Something.
You get an
That,
extra
I'm gonna
3 hours.
bilocate, I don't know.
Is February reasonable?
February's better, yes.
February reasonable?
You wanna do, Bob, can I take the subdivision regs to them without the public hearing, have them review it, and then do a public hearing, or do I have to do the whole thing in a public hearing?
I think you could do a review and then have a public hearing.
Okay, let's do that,
February?
yeah.
Okay.
I'll get it to you, because I know, you probably all know this, I'm sure you know this, the subdivision regulations don't require town council approval, it's just you, public hearing. And so if you guys are at a level, and I think it would be good to have a couple of meetings on it, outside of the public hearing, just so there's opportunities for the public to talk about it on more than one occasion.
That sounds good.
Okay,
That's all I got.
all right. So moving over to the next page here. January 26th, planning board meeting quorum confirmation. We already discussed that to start with, I think.
Well, just for the January meeting, is everybody going to be here? Or,
Yeah.
Yes.
Be here.
All right.
Unless I have another kid in a month.
Whoa, no. State population and employment outlook by the town. My only thought there was, it's interesting that we have about 14,500. And we're going to have 13,500 in the next 25 years. Now, I don't know about you people, but listening to people predict, right? Once you go beyond 5 years, I mean, how the hell can they predict 25 years from now, how many people are going to be living in this town? If we're half underwater, then, you know, that takes care of that. That's it. I mean, right? I mean, well, I read but in any case, do we have to discuss it, or is it just
No.
informational?
Nope, just informational.
Yeah, okay.
To your point, Doc, it would be interesting to see what their forecast was 5 years ago.
Oh, how it's changed, yeah.
Yeah,
Oh, that, what that forecast was.
Yeah, it struck me when I looked at the numbers for North Kingstown. I mean, you guys are, so many housing units under construction and being built, and they show a population decline.
The population today is smaller than it was in 1973.
Yeah, but I mean, you're adding a lot of units, right?
How does that work?
Close to Navy base in 73.
Kids leave. Five-person household becomes 2.
Yeah.
That's going on all over the state, all over the country.
just not to get too philosophical, but I drove into Rhode Island in 1965 and drove up to the naval base there, and the population at that time of the state was shade over 1 million. And then we lost the Navy, and all kinds of interesting changes have happened in these many, many years, and everybody knows what the population is today. It's a shade over 1 million. So I mean, the whole business of predicting population, you know, when we lost the Navy, everybody knows that. We lost the fleet, I mean, the whole Atlantic fleet, and all the ancillary folks, and here we are. So, who knows? Any case, anything else we should talk about?
Did you appoint someone to the Coastal Access Improvement Committee? I missed it.
I was asked the
That's
same
what Joe was
thing.
at.
Yeah, I thought, when were you appointed?
Maybe I wasn't appointed.
I'll make a motion.
Turn it
I
on.
You might get appointed forever.
I thought it was discussed and before,
I thought that was
You're right.
I think
like
Mark-
subcommittee.
Yeah,
This is
Board
just,
member,
missed that one too.
subcommittee.
I think
kind
Mark
of
did it.
thing.
because I made the joke
You might have
about it.
discussed it, but it was never an
I don't-
agenda
yeah,
item
I
to
don't-
appoint
so-
anybody.
Yeah.
So that's done.
Are you doing it, Rupert?
Motion by Jim,
Motion
seconded
by-
by,
I'll throw a second in that one,
Okay.
as long as you're not on other committees, right? We can only be on
I've
2
been Shanghai
appointed
again.
committees, so
There you go.
I don't know how many you're on already.
It's fine.
Congratulations.
All right.
So we're all in agreement.
5-0, thank you.
All right, so next thing we do is to say goodbye.
Move to adjourn. Move to adjourn.
Move to adjourn.
Move to adjourn,
Need a second?
second. You got a second?
I'll second.
All right. All in favor?
Aye.
God bless America.
God bless.
Two.